Okay, ladies and gentlemen, a pleasant good morning to you all, and welcome to the second day of this very interesting and important conference that is focusing on the issue of specific legislation to protect the rights and dignity of persons with disabilities in the Caribbean under the theme Securing Participation, Inclusion, and Non-Discrimination of Persons with Disabilities Through Legislation. Once again, I want to thank wholeheartedly our partners who have contributed immensely to make this event a reality, and specific mention of the University of the West Indies, the Commonwealth Secretariat, UNESCO, and Digicel Foundation. We are going to have a very stimulating and thought-provoking day of activity, because this is where we get into, as Jamaicans would say, the nitty-gritty of the conference. We are going to be starting out with a conversation with Miss Akiko Ito from the UN Secretariat. We are going to be having a dialogue with a number of our Commonwealth partners who have established disability-specific legislation for years. And so they will share with us from the United Kingdom, Mr. Richard Reeser, my friend, Dr. Samuel Kabui from Kenya, another of my friend who is online, and they are 8 hours ahead of us. They're just after 5 o'clock in Kenya. And then Miss Rosemary Chaos, who is the chairperson of the Committee on the Rights of Persons with Disabilities, but in this instance, she will be doing a video presentation on the experience of Australia in terms of its legislation. Then we are going to venture into a breakout session with the participants of the conference. And this is where you get the opportunity now to participate in the actual conference by sharing your views on the issue of the specific legislation. And you will be placed in breakout groups. Those have been set up already, and we're working on those to place you in those breakout groups. Then we go into a report from the breakout groups. After that, we have a general discussion, a presentation led by my partner who worked with me on the template, Miss Tamisha Powell, an attorney at law, and she will be taking you through that aspect of the conference. And after, we will have a discussion with all the partners, stakeholders, and this is where I'm going to be banking on the ministers, the permanent secretaries, and attorney generals within the region. And I implore you to make sure that you are involved in that session as well, because we want to get some commitments from the governments who are represented in the conference of a time frame for the implementation of the legislation to protect the rights and dignity of persons with disabilities in the Caribbean. We want to have some outcomes from this conference. And those who know me, they know that I will be knocking at your door even though I'm not invited. I will be knocking at your door because I am on the mission to ensure that my brothers and sisters with disabilities in every single Caribbean island, whether it be in Jamaica, whether it be in Guyana, whether it be in Antigua or Bahamas, wherever they are, Suriname, St. Martin, wherever they are, we want to make sure that our brothers and sisters with disabilities are protected and brought in the mainstream of Caribbean society, because for too long they have been isolated and their talents suppressed. And we want to, as the University of the West Indies mission says, unlock the full potential of the peoples of the Caribbean. Ladies and gentlemen, I thank you, and I now turn over to Dr. Christine Hendricks, who is the Executive Director for the Jamaica Council for Persons with Disabilities and an advocate for persons with disabilities in her own right, and a committee member who has assisted in the formulation of this conference. And I want to make welcome and turn over the day's proceedings to Dr. Christine Hendricks, who will anchor the session. Welcome to you all, and thank you very much, whether you are in the United States, you are in the UK, Kenya, Australia, wherever you are in the Caribbean. Welcome to day 2 of this very important conference. God bless you. Oh man, when you come here, you can just stop. You don't need it. Just use the mic. Right. Once the mic is open. All right.
Good morning, my fellow colleagues in Jamaica and the Caribbean, those who are in-house and those who are online. It is such a privilege having everyone here this morning. Let me thank the Senator for kickstarting our session this morning. And now to introduce our first speaker. In this session, we will have a special presentation from Ms. Akito Aito, and she will look at the historical relationship with the United Nations and persons with disabilities in the Caribbean, along with some other important issues pertinent to the development of legislation for persons with disabilities. She will speak for 15 minutes, and we will have another 15 minutes for question and answer. Ms. Akiko Aito is Chief of the Secretariat for the Convention on the Rights of Persons with Disabilities and UN Focal Point on Disability. Ms. Aito has extensively lectured and published on issues concerning disability and human rights at the United Nations. Previous to her current post, she worked in the Legal Affairs section of the United Nations Drug Control Program in Vienna, Austria. Her academic background is in international law. She focuses on the domestic application of international law and the rights of minorities and other disadvantaged groups. Ms. Aito has an LLB in International Legal Studies from Sophia University, Tokyo, Japan, and Masters in International Relations from the University of Chicago, and LLM from Boalt Hall School of Law, University of California at Berkeley. Let us put our hands together and welcome Miss Akiko Aito.
Thank you very much. This is such a great pleasure for me to be with you this morning. I'm speaking to you now from my home country, which is Tokyo, which is Japan, where the Olympics and Paralympics are taking place. And we always wanted to emphasize that what. For example, this Olympics, a global event, global conferences that we actually place in the center the participation of persons with disabilities as an essential condition and the basic tenet and the most fundamental aspect of anything that we do. And as the United Nations or as member states or as any stakeholder, I think this is really important for us to, especially now in Tokyo, we see a lot of, participants who will be coming to Japan to participate in Paralympics. So I just would like, it's a great pleasure to speak to you from here. And I would like to express my great appreciation for this invitation to Special Ministerial Conference on specific legislation for persons with disabilities in the Caribbean. This invitation by the distinguished institutions is in the Caribbean region, University of the West Indies, Center for Disability Studies, and also in association with the CARICOM, and also the Office of a Special Rapporteur of the CARICOM on Disability, and support from the Commonwealth Secretariat, Digicel Foundation, and the UNESCO, United Nations Educational, Scientific, and Cultural Organizations, which is our specialized agencies of the UN system. I would like to acknowledge with deepest gratitude, first of all, for the global, regional, and national leadership of Senator Floyd Morris, member of the United Nations Committee on the Convention on the Rights of Persons with Disabilities, CARICOM Special Rapporteur on Disability and Director of the UWI Center for Disability Studies. I had the privilege of working with the Senator Morris and the government of Jamaica and other Caribbean nations governments at the time of the negotiations for the Convention on the Rights of Persons with Disabilities. In 2002, Jamaica spearheaded its leadership from the Caribbean region to take the leadership role in participating in a discussion to negotiate then the convention, then an international convention with regard to the rights of persons with disabilities. And as a secretariat to the ad hoc committee, the General Assembly ad hoc committee that drafted the CRPD, I recall that Jamaica made major contributions to the development of the CRPD. In 2004, I also recall that I had the honor of attending a key ministerial meeting, which adopted the Kingston Accord and provided a strong political support to then the ongoing treaty process of the CRPD in New York, headquarters in New York, the United Nations. We understand that the CARICOM Secretariat also continues to make progress in advancing the disability agenda, building on the declaration of Pétionville, CRPD, and the SDGs. So I understand that the leadership that the region took for negotiating a treaty on the rights of persons with disabilities and addressing the importance of participation of persons with disabilities in the process, you're still continuing to take the leadership and making specific progress in advancing at this time the disability agenda in the context of the implementation of the CRPD, and that strength of that legal force of the CRPD to be taking forms in the disability inclusions in the 2030 development agenda and its sustainable development goals. I also want to further congratulate the government and all other stakeholders in these ongoing efforts. And I would like to express our deepest commitment to work with you to make the goals of the CRPD and the 2030 development agenda and its sustainable development goals, and to support your leadership in making those goals a reality for persons with disabilities all over the world. Today, I would like to share from something that's directly relevant to everything that we have on our agenda in this program, namely how UN system has been promoting the disability inclusion in a response, recovery, and building back better from the COVID-19 crisis. I was thinking that everything that we do and everything we had known previous to the COVID-19 crisis and everything we know now because of the COVID-19 crisis is more about, again, using, all of those, this information, the experience, lived experience, and ongoing, good practice and ongoing obstacles that we face, all of those in a package for us to be able to steer ourselves back to the implementation of the CRPD and in the 2030 development agenda for and with persons with disabilities. So in this context, I thought it would be important for us to be able to share specific efforts that we are making in relation to the disability inclusion in this Building Back Better period. Of course, as you know, COVID-19 crisis is still continuing, and then there are many parts in the world that still very much in a crisis and response situations. But I do hope that our continuing efforts together will address both the COVID-19 recovery and our steering us back to the CRPD implementation, and therefore the disability inclusion in a global agenda, people with persons with disabilities as a key stakeholders, and as also implementers, and as evaluators, and also as those the agents and leaders in our global agenda as well as national agenda. So in the context of, as you may recall, COVID-19 crisis has been now with us for the past year and a half. And this has exposed the extent of the marginalization and inequalities faced by persons with disabilities and other disadvantaged groups and individuals. And we all know that this situation has heightened pre-existing barriers to accessing, for example, basic necessities, services, and our available data shows that it raised new barriers against those who had already been disadvantaged, including persons with disabilities. And so we actually were at the time of this crisis taking place, we focused more on identifying the pathways to address disability and COVID-19 response and recovery. The Office of the Secretary General issued the policy brief, Disability Inclusive Response to COVID-19, in a time-bound task force for its mobilization. Our program, which is housed in Department of Economic and Social Affairs, we also issued a policy brief on COVID-19 crisis from disability and gender lens. And the disability inclusion strategy continued to advance disability inclusion across all pillars of the UN's work, taking into account those barriers that, and then also the heightened barriers and the new barriers that the people with disabilities are now facing, in the context of this crisis response and recovery period. And other UN agencies, entities, also have been contributing a series of disability-focused events, conferences, publications, or programs created in collaboration with member states, including the Caribbean, from the Caribbean region, and also organization of persons with disabilities, including the focus on health, humanitarian emergencies, gender, and socioeconomic situations under COVID-19 crisis. We've been trying to leverage partnerships, in terms of how those intellectual resources that we built may be mobilized, and we may be able to promote action on the ground. We've been trying to leverage partnerships, and including United Nations Partnership on the Rights of Persons with Disabilities. And with a view to strengthening the knowledge management, but also to effect many projects on the ground for building back better, recovery, COVID-19 recovery, and building back better. Our segment, our program itself is developing an inclusive and accessible UN system gateway, and which includes the studies on socioeconomic impacts of the crisis on persons with disabilities, while applying disability inclusion as a cross-cutting principle. And this site will be made available this coming month, in a few months. And we are hoping that we will be able to obtain good practices from different regions. And since we have this benefit of this conference, I would like to also propose that we harvest from your discussions, and also taking into account all of those previous, again, contributions from yesterday program. We would also like to maximize the important contribution of the Caribbean region and its stakeholders. So just wanted to make a special request for such provision of the information from this conference. Through the 13th and 14th session of the conference stage parties that took place in December 2020 and just recently in June 2021, many stakeholders also came together to take stock of such lessons learned and opportunities for building back better. The 14th session of the conference that took place 15th to 17th June, just last month, it discussed next steps for Build Back Better under the specific themes of humanitarian action, independent living, and being included in the community and education, with a particular focus and leadership of persons with disabilities in the decision-making process. And especially for, in a context of COVID-19 and for the transformative change that is very much needed on the ground. I think these issues will be able to provide again more opportunity. These issues and the forums that that the spaces for discussion that's been created by COSP14 will also continue to provide different types of networks that is focused on those issues. And I would also like to just add that networks that we have been building during the past year and a half in those key priority issues, such as taken up by the Conference of States Parties, if they're open for more stakeholders to join, and we are hoping that the report of the Conference States Parties this year would also again continue to serve our stakeholders, and especially those that have already taken leadership to continue supporting other stakeholders to promote the disability inclusion in taking advantage of this kind of a urgency, sense of urgency, this space that's opened up because of the current COVID-19 situation. We have to seize these opportunities, I think, to set new standards and norms, which I think pertains to this conference, and forge partnerships and strengthen institutions to build barriers, to build bulwarks against the devastating impact of any crisis in future, any pandemic or any other crisis in future. And I think we can do so only in solidarity and maintaining strong motivation to continue to build a post-COVID-19 world in close alignment with the Convention on the Rights of Persons with Disabilities and the 2030 Agenda for Sustainable Development. I believe the UN system in this context could still undertake more initiatives to explore these pathways in the ongoing institutional and community efforts toward better recovery and building back better, including in the Caribbean region. So those are some of the key issues that I just wanted to raise in today's context, which are directly relevant to the discussion that we are having today in this program. I would like to express my appreciation once again for this opportunity to speak with you and to share with you the ongoing work of the UN system. And as I said, I'm looking forward to the report of this conference, and also to make this intellectual resource available from this conference for our constituencies all over the world. And thank you so much. I stop here. Thank you.
Yes, thank you so very much, Ms. Ito. Yes, having shared with us the journey of Jamaica and parts of the Caribbean with the UN body, and particularly the work with the senator on the CRPD and the committee there, and the continued work of the UN with other states parties as we seek to build back better. We know that the Conference on States Parties just ended in June, and perhaps there were persons who are on this conference who were participants in that conference. And so we continue to look towards ensuring that as countries, seeking to ensure the rights of persons with disabilities, that we do not leave people with disabilities behind. So thank you so much for your presentation. We will now take questions from our participants here and online. While we do that, let me just take the opportunity to ask all the participants to ensure that you write your names and your countries in the chat so that we can have a register of those persons who are here, also for the breakout rooms for later on. Thank you. Okay, Senator has a question.
Thank you. Thank you very much, Madam Chair, and thanks to my friend, Ms. Akiko Ito, for our excellent presentation as usual. And I remember those days, Ms. Ito, when we used to traverse to New York on a regular basis to participate in the negotiations on the CRPD, and you subsequently coming to Jamaica to participate in the dialogue on the Kingston Accord. So we have a long history and association, and we continue in the struggle to make this world a better place for persons with disabilities. What I wanted to find out, Ms. Ito, I've taken note that basically all the countries within the Caribbean have signed and ratified the CRPD, but there are only a few that have signed the optional protocol. Either 3 or 4 countries have signed the optional protocol. How important is the optional protocol in terms of providing protection for persons with legislative protection for persons with disabilities?
Ms. Aito, you are muted. Can you just press?
Yes, I'm muted. Yes. So thank you so much for this question, Senator Floyd Morris. And once again, it has been such a great privilege to work with you during the past decades. In relation to this again optional protocol, I understand I also went back to our website and OLA site and checked the Caribbean. Again, the region and the countries, in relation to the optional protocol and the CRPD, and how important it is. Of course, I believe that international legal monitoring mechanism, which is part of our international human rights system, because our office is not part of the OHCHR, which is OHCHR is the one that deals more with the human rights system and mechanism. And as you know, we actually focus on the use, the legal force of the CRPD and its strengths to the disability inclusion in a broader global agenda, and that is more of our focus. So we do not, from the standpoint of our office, we are not in a position to do more analytical work on this. I think this is more like area of the Office of High Commissioner of Human Rights to look into, again, for example, the effectiveness of, monitoring mechanism of different regions and different countries in relation to the ratification of optional protocol to the CRPD. But I have since we are not, this is not a part of our work, I do not have the specific sort of answers to it, but I do believe that, from the context, from our context, from the development perspective, I do believe that, when it comes to international legal mechanism, if we have specific legal mechanisms that could focus on the CRPD, the disability perspective, and then to impact on the human rights protection. And that, in turn would immediately impact on the governance, in its entirety. And I do believe the optional protocol is also an important means for, it's one of the important mechanisms that could provide a strong basis for the implementation of not only the implementation of the CRPD itself, but I think it would also impact on the broader goal of strengthening human rights mechanism and human rights system, and that in turn will impact on again the governance. In the context of political dimensions and many other institutional contexts. I think that would really, that is something that, I do not have any analytical work that has been done by our office, but I do believe that that many of the academic institutions have been addressing this issue and the importance of, again, the ratification of both optional protocol and the convention. It's an optional protocol for such systematic, protection of human rights, which is not only to that convention, but just because of the broader, benefits and strengthening of the human rights protection in those countries. So it's just a very broad answer, but
Thank you very much, Ms. Ito. I guess perhaps others would be wondering too if the optional protocol offers the opportunity for whether individuals or organizations to report matters of discrimination to the international body, if it is that they have not or are not receiving the necessary or the relevant, not support, but having heard from their local body or their local tribunal, if it is a tribunal, then having not being, if they are not satisfied, then they can always take it to the Committee on the Rights of Persons with Disabilities. Would the optional protocol offer that opportunity?
Yes, I think you're
Ms.
right.
Ito?
Yes, thank you. Even though like it's not, again, I would always, this is just what, we understand as the fact that, one needs to exhaust all national, domestic, again, procedures before they can actually again file this the case with the committee itself. So I think exhaustion of all the remedies at domestic level is a precondition or requirement before this optional procedure and under the optional protocol can be initiated. So I think it's an important point. I think I think that also helps national level again judicial mechanisms to be able to also to receive those cases, and the optional protocol itself makes it a requirement for this to happen before it's reviewed by the committee itself.
Okay, thank you. Another question here. Is it a necessity to have, is it for Ms. Ito or just generally? Okay, so question here, is it a necessity? Oh, it is a necessity to have a registry for persons with disabilities. Given the challenges or concerns regarding privacy, as well as the possibility of hierarchy of treatment for persons with disabilities who opt not to be registered vis-a-vis those who are, how can member states ensure that the rights and dignity of persons with disabilities are still advanced in this area?
Thank you so much for this very important question. I think this question actually could not only remain in the disability field, but in many other aspects of the work that the governments all over the world need to deal with in terms of disadvantaged groups and especially in relation to this privacy. In today's world, of course, I see in internet communication technologies, and now it's a world of AI, so artificial intelligence, and there are a lot of the technologies and information data. Again, being brought together in a way that nobody had were able to imagine, how it could be used for of course for appropriate purposes, for government's purposes, or for many other legitimate purposes. But in relation to privacy, I think there are many concerns that are expressed at different experts by different experts and different governments, and I think this issue has started to be part of the discussion. I just attended an event organized by ITU a few months ago. But this issue of privacy and human rights and an information society worldwide, it has always been an important and very crucial topic that is now becoming more and more an essential part of for any human rights discussion. So while I don't really have any specific answers to how we can protect privacy, in relation to human rights in today's world, with in the absence of specific context or perhaps discuss specific examples, which we may actually have in terms of compilation of some good practices, perhaps. But this area is, I would just like to say that this area, this topic really needs to be again examined by all stakeholders that are involved, especially persons with disabilities themselves, because our many decades of experience show that even now, discussing accessibility is not just mechanical. It's aspect of technology. We now currently organizing an expert meeting, but this one expert with autism, autistic conditions, mentioned that he does not really wish to see all when he sees that it's a screen, he is not able to again to address. He cannot really address when there's so many again people on the screen. That for him, he cannot see too many people on the screen because of his conditions, and but he does not really want people to know this, for example, for participants to know this. So we are now trying to see how best we can make accommodations, maintaining his privacy, but also ensuring that his rights, his well-being will be maximized, and to the extent possible, of course, to make reasonable accommodation to the extent possible. But we are doing this on the ground. So I think there are many different ways of addressing it. In small meetings like what I'm just our technical meeting, to a global meetings, or maybe even legal procedures, and many ways that many innovative ways that we need to come up with in order for us to protect individuals' human rights. So I just stop here.
Okay, thank you very much, Ms. Ito. Any other questions? I'm not seeing any in the chat. Let me see if anybody's raising hand. Okay, I'm not seeing any other question. Okay, since I'm seeing no other question, let me say thank you very much again to Ms. Ito for her presentation and for the questions that we looked at this morning. All right, we're running straight over now to our next segment, where we will be having some panel discussions, and Ms. Gloria Goff will be chairing this session. So we invite Ms. Goff, the Executive Director of the Combined Disabilities Association, an advocate for many years in the disability sector, who will now take the chair. Thank you very much. One second. It's on. You want it off? Yeah.
Good morning. Good morning, everyone. As Dr. Hendricks just said, I'm Gloria Goff, and we are in this session going to be looking at the experiences of persons in the Commonwealth. And we'll be focusing on the UK, Australia, and Kenya. And we have three excellent presenters who will be presenting. And I'm happy to say I've met two of the three, Mr. Reisa and Mr. Kabur. I've had the pleasure of meeting them, and I know you will learn a lot from the three presenters. So we will begin with Mr. Reisa. So let me introduce him. Mr. Richard Reisa is a leading disability advocate, an expert disabled international trainer, a consultant, filmmaker, writer, teacher. He has served as chair of the Alliance for Inclusive Education and represented the UK disability in New York at negotiations on the UN Convention for the Rights of Persons with Disabilities. He's currently the managing director of World of Inclusion Limited. Mr. Reisa also recently received the Order of the British Empire. Mr. Reisa, we welcome you to our conference, and the mic is yours.
Thank you very much. Can I share the screen?
Okay.
Can I share the screen? I think I can. Can you see that? I mean, it's no good asking you to. Is the PowerPoint up? Can someone confirm that?
Yes, it is.
Thank you.
Yes, you can.
Yes, it is.
Okay,
Yes,
thank
it
you.
is up.
Okay, thank you. Okay, so I was asked to talk about the experience of implementing disability legislation in the UK. I will do this from the UK point of view, but I think there are points that come out from the work I do as General Secretary of the Commonwealth Disabled People's Forum as well. So the first thing I think that we learn from looking at the UK, going back more than 130 years now, or nearly 130 years, is that the gains that we've made have been largely gains that have been fought for by disabled people themselves. Going back to 1894, the National League of the Blind had a long campaign for guaranteed jobs and conditions in the workshops where basically blind people were being massively exploited. They had a march on Parliament from three parts of the UK, and eventually Lloyd George passed a bill in 1920, which gave them some of what they wanted, but not most of it. Equally, from the 1890s, the British Deaf Association, originally known as the British Deaf and Dumb Association, were campaigning for sign language after the world decided against sign language. Many of you may not know this. In 1880, in Milan, there was a conference to ban sign language as the means of communication for eugenicist ideas that deaf people would overpower hearing people, ridiculous thoughts that we get around the place. They had a long, long campaign, and in 1994, they actually managed to get sign language adopted in the UK. So some of these campaigns take a long time. After the First World War in 1919, the Disabled Soldiers and Sailors Association fought with direct action, including some not so good actions, such as burning down Luton Town Hall, for a land fit for heroes that they'd been promised. They didn't get all their own way, but the government wheeled in the British Legion to try and head off the militancy of this group, and at least disability pensions were provided. But interestingly, there were less than half of those that were provided to disabled soldiers in Germany who were defeated. So it wasn't a very good view, and it always relied on the charity model in the British situation. In 1922, the Disabled Drivers Motor Club was set up by 6 disabled officers, and in 1948 merged with the Invalid Tricycle Association. And their action led to 2 things: the Chronically Sick and Disabled Persons Act, and also the Motability Scheme, which now has more than 600,000 people who can use their disability or living allowance mobility component to hire a car on fleet terms. There was also the Disablement Income Group in the 1970s, who largely helped to push forward the Chronically Sick and Disabled Persons Act. And out of that, we got the first intonation of independent living in the 1970s, the first disabled people who got direct payments, which then became law some 20 years later, so that instead of being looked after by social services, you could actually receive the money and employ people yourself to look after you. But many disabled people, particularly the generation that were allowed into universities, many of them for the first time in the 70s and 80s, were dissatisfied with this. And the British Council of Disabled People was set up. And then later the Direct Action Network, who didn't feel that things were going quickly enough in terms of getting comprehensive, enforceable disability rights legislation. And as a case in point, the Disability Discrimination Act, which was one of the first, I think after Australia and one other country, to be enacted, was more described as a leaky colander than a piece of human rights legislation by Lord Leicester. It was very inadequate, and even to get that, we had to have 17 attempts in Parliament, and Mrs. Thatcher's government was opposed to it, but some members of it broke with the government and eventually pushed it through. But that may explain why it was so weak. We had to continue campaigning to get an amendment to include things like education, and then further amendment in 2005. Eventually, all of this was consolidated into legislation in 2010 called the Equalities Act, which is still in force, but in many ways weakened what we had at the time. So you can see the history of what has happened here. Very much medical charity model. The direct action, I put some pictures up on the screen now, it required this action to block Westminster Bridge with disabled people chaining themselves to buses, front, back and underneath them, protests, throwing paint at Downing, red paint at Downing Street, crawling up the steps of Parliament and so on, to embarrass the parliamentarians who had no good reason not to enact the legislation. As I say, it was the 17th attempt that it actually finally got through. And that direct action is now acknowledged as tipping the balance towards it. So the structure of the Disability Discrimination Act, first of all, the definition is a medical model definition. It is not even in line with the one of the UNCRPD, even after we'd signed the UNCRPD in 2010 in the Equality Act, we still have this individual medical model definition. If you have a long-term physical or mental impairment which has a substantial, which is more than minor or trivial in British law, impact on your ability to carry out day-to-day activities, then you are a disabled person. One thing that's in the definition here which is useful is that in determining this, you must discount aids, appliances and medication. So if you are an epileptic person with control, which is control with drugs, you must ignore the impact of the drugs to define the person as a disabled person. If you use a wheelchair and you can get around fine, you need to ignore the wheelchair to see how a person can do on ability to carry out day-to-day activities. Similarly, for people with intellectual impairments and so on. So that has been useful in winning many cases. It applies to employment, goods and services, transport as the main areas. There were lots of gaps, as I said, and it was capable of being enacted in law with cases brought in the county court and then the appeal court for direct discrimination, indirect discrimination, failure to make reasonable adjustment, which is our version of reasonable accommodation, and protection from harassment and victimization of those people who are bringing such claims. So that was the very basic structure. One of the reasons why this emerged was there was a Rights Now coalition, which was the big six disability charities like Scope, like RNIB, which are not run by disabled people, but run by people who want to do good things for us. And they were happy to go with the first draft that the government put forward. Disabled people's organizations themselves did not want that and were against it. And therefore, the disability rights movement got split at this point. And the main protagonists of the disability rights movement went on campaigning. And they got a commitment from the incoming 1997 Labour government to set up a commission to look at filling all the gaps in the legislation. And while that government didn't commit and fulfill everything it said it was going to do, it did, with 2 amendment acts and a whole series of things, and indeed setting up a Disability Rights Commission and then an Equalities Commission, implement many of the things that were missing. Though they didn't go as far as they perhaps should have done, and there was still a tussle over how far employment legislation should cover all employees. The government, Labour and Conservative, drew the line at 20. Interestingly enough, we were still part of the European Union at that time, and the European Union Equal Employment Directive said it should apply to everybody, which meant when we had to sign that as members of the European Union, another 7 million people were covered in their employment. And that remains the case now, even though, as people will know, we've left the EU, and many of us in the disability movement are very worried that the EU did produce much stronger legislation than we have in the UK, and we've already missed out on some, such as access to products, which was a new directive that went through as we were leaving the EU, which there is no evidence that the UK government currently will want to implement it. So other things about the weakness of the legislation. Education was left out almost entirely. There were 1 or 2 things about whether a school was accessible or not, but there was very little else there. And so it required a 2001 Amendment Act to bring all schools, colleges, universities under the Disability Discrimination Act, and a duty on all local authorities and publicly provided schools to have an access plan to improve the access to the curriculum, to the environment, and to different forms of communication such as sign and braille and so on. That is still on the statute book and remains part of the Equalities Act, but it is largely ignored. And that is one of the problems that we have is enforcement. I'm going to say more about enforcement in a minute. There was no public sector responsibility to promote equality. This was altered by an amendment from the commission that was set up by Labour in 2005, and we had a duty, a public sector duty, to promote equality on all publicly funded bodies. And that was a big step forward. And in the 5 years that it was detailed, it led to a great deal of positive things happening. But many managers in the public sector have said it was too much of a burden. And so when Labour came to draw up the 2010 Equality Act, they weakened it very considerably. Interesting now, in their proposals for 2021, the Equality and Human Rights Commission are arguing for a strengthening of it again. So There was very little responsibility on landlords in shared spaces to make any reasonable adjustments. The access to buses, trains and taxis was very long lead-in, and most taxis were not covered. The lead-in went from 1995 to 2017, and then it only had to be new rolling stock. Again, the European directives, which came in the interim, required all rolling stock to be moved to being accessible, including buses over 20 people. Many buses are still not covered. And so that was, again, another gain. Access to products, as I say, was not covered. Buildings section, we have no general code on access, which we really require. There were
2 minutes.
Hello?
2 minutes.
Okay, thank you. Then mental health was not covered. Post-UNCRPD, the UK signed in 2009, including the optional protocol, but put in reservations on education, immigration, legal capacity number 12, and employment concerned about the armed forces. The austerity measures that were introduced after the 2008 crash by the Conservative government have led to huge breaches of human rights, and the UNCRPD committee on a protocol inquiry, optional protocol, found the UK government to be grossly in breach of that, as did the UN reporter on poverty. UNCRPD committee was highly critical of the UK government in 2018. Weaknesses shown up in COVID, which has already been mentioned by Akito. 66% of the 128,000 deaths are disabled people. And if you have a learning difficulty, it's 6 times more. These are shocking and have been authenticated by the Office of National Statistics. Lessons from our experience, just to finish up. Governments need to support and help develop the capacity of representative disabled persons organisations. That is a key requirement so that they can actually represent the views of disabled people as the legislation is formulated and implemented. They must consult mainly with disabled people's organisations rather than organisations that say they speak for us. They must focus on implementation with effective regulations such as buildings, access, requirements on service providers and employers. Promote disability equality in the public sector through contract compliance and employment and awareness raising, and enforcement should not be left to the individual. I cannot stress this more. The reason why UK legislation has largely failed to actually change the situation is because it is left to individuals to take a case to court or a tribunal. This should actually be being done by a human rights body, as we do with, for instance, enforcement of health and safety at work. And therefore, it should be a generalised requirement on all service providers, employers, educational providers, and so on, to actually implement the legislation, not left to individuals to force the situation. And so there are some strong lessons. We did have an early experience of the disability discrimination legislation and going back many other things. But really, we are now fighting very hard through Reclaiming Our Futures Alliance and other pan-disability organisation in the UK, Disabled People's Action, and so on, to actually really get government to listen to us. And there's no signs that they are. In fact, Lord Shirkin, who's a Tory lord, wrote in The Guardian last week that the consultation for a national strategy is likely to be a massive car crash for the government when they publish it this week. So we aren't really moving forward on this issue at all. And I think it's a great shame, but there we are. Thank you.
Thank you. Thank you very much, Mr. Reis. A very, very interesting presentation. And much of it reminds me of Jamaica in terms, and I'm happy you gave the history of how it all started from way back World War II, I think World War I. And I think it's always important to have the history of how the disability movement, how we got to be where we are now, for the younger generation to be understand and maybe be more appreciative of the struggles that we went through and the struggles that we now have to continue, because you did point out a number of weaknesses in your act. And like ours, as you review, you will realize that much of what we said then will have, or not necessarily what we said, but what was maybe changed or modified in the construction of the act, that we now have to revisit and advocate for the change. We're happy though that unlike you are able to give statistics in terms of the persons with disability affected with COVID and who have died from COVID. In our country, that kind of data is not captured readily. So thank you very much, Mr. Risa. And although some of the issues you raised in your presentation regarding your act will help us to when we do revisit ours. Now we're going to go to the next presenter. And we're doing the presentation, then we have question and answers. So we're now going to we're going to Dr. Samuel Kabua. This is another gentleman that I mentioned earlier that I met in person here in Jamaica and have spoken to subsequently. And really, Mr. Kabua is someone you'd love to meet, because not only does his Christian principles and so on stand out, but also his strong belief in the disability agenda. So I'm going to introduce Dr. Samuel Kabua. He has been a critical member of the Ecumenical Disability Advocate Network, which is referred to as EDEN, and the National Council for Churches of Kenya, where he established a disability program. As director of the advocacy unity within the National Council for Churches of Kenya, he worked on civic education, economic justice, peace and reconciliation, gender justice, youth work, disability and family life education. He holds a Master of Education degree and graduated with a master's degree in theology from St. Paul's University, Limuru, Kenya. In 2011, he was awarded a Doctor of Divinity degree by the Senate of Serampore University in India. And with all those and more accolades, I hand over to Dr. Kabua.
Thank you very much, Gloria. And I am glad this evening it is evening in my country to reconnect with old friends like Gloria Goff and Morris, Floyd Morris, and probably others that I may not know whether they are online. Yes, I was also asked to give our experience with the implementation of a legal framework in this country. And like Richard, I'll go back a little to how we all started. You know, Kenya was a colony of Britain. And in the Second World War, a number of Kenyans were taken to fight for Britain in various parts of the world. And a number of them were injured. Some of them became blind. And as a result, a rehabilitation center was established in Nairobi by the Salvation Army Church in 1943 for those who were coming back injured. And this eventually developed into the first school for the blind in 1946. It admitted younger people from 1946, and it was the first experience of blind people going to school. And the students who, of course, went to this school, many of them went at the late age, started thinking of how they were being treated in the school and started feeling that they also needed a voice in what was happening in school. And during those colonial days, it was difficult for people to really raise voices that are in opposition to the benefactors for this matter, the Salvation Army, who were the people who were running the church. And so they came up with an association. They called themselves the Kenya Union of the Blind in 1959 to be able to negotiate with the external authorities on their own lives and what they needed to see done for the blind people and actually for people with disabilities in general. In 1961, this organization became very, very strong. And as you probably will know, in 1963, Kenya became independent from Britain. And when Kenya became independent, these people who had formed the Union of the Blind were the first to see the president and to tell him that they also needed to be recognized in the developments that were taking place. And by 1964, they had not seen any signs of recognition. And they held a demonstration in the city of Nairobi. They held on a rope. Many blind people held in a rope led by one who could see a little ahead, and walked from one side of the city, and they wanted to end up in the office of the president. They were intercepted on the road, and they were told that they would be taken to the president, but some of them were too clever, and they learned that they were about to be put into a lorry and be taken away. So they sat down on the road and said they did not want to go. And it was a drama in the new independent country for this kind of a situation. So the then president, he was the prime minister, Jomo Kenyatta, heard of this commotion, and he sent one of his assistant ministers to go and talk to them. And he told them to choose two of their representatives to meet with him the following day. And that began really the journey to interaction of the government with the people with the disabilities, because after this, there was a commission that was formed, not because of the blind people, but because of the general development that were taking place in the country. And this commission did, among others, consider the situation of persons with disabilities. Some of them had gone to rehabilitation centers, but they were going back home without really being able to be included anywhere in places of work. And this commission even provided for the formation of what was called Sessional Paper number 5 that established rehabilitation centers by the government for the first time, 12 of them in the country. And these rehabilitation centers now started training people with disabilities and placing them in possible employment. But people were still not very satisfied with what was happening. You will remember the IYDP, International Year of the Disabled, in 1981. And because of the recognition that has been made of the situation of persons with disabilities in the country, the then president, Daniel Arap Moi, decided to have a year of persons with disabilities in Kenya prior to the international year. So 1980 became the National Year of the Disabled in this country. And this was again the beginning of formation of organizations of persons with disabilities. Groups came together, and they found it necessary to work together. And led by, again, the Kenya Union of the Blind, we found the formation of the National Association of the Deaf and the Kenya Society of the Physically Disabled. And after 1981, you will also recall that DPI was formed. And out of the influence of the DPI, these organizations came together as a cross-disability organization, United Disabled Persons of Kenya, to form this body as a common voice for them to negotiate their affairs. I was the first chairman of that group, and we began thinking about the law and persons with disabilities at the same time. And we approached the Attorney General of this country and told him we want to engage with the government over the issues of the laws that did not favor persons with disabilities and need for laws that would give people with disabilities identity and place in the society. The Attorney General was very gracious. He had some connection with disability in the family, not himself, but in his family. And he came up with a task force to review all laws and to consider what needed to be done with the persons with the disabilities. Again,
5 minutes, 5 minutes.
Thank you.
5 minutes to.
Thank you. Again, I was lucky to be part of that task force, and we worked so hard for 3 years. We came up with a bill. We came up with a long report, but the Attorney General was a lone prayer at the time because the government was not very keen on what he was doing, and the Parliament was not. And it was not until 3 years later that this matter was revived. In 2002, Kenya changed the leadership from Moi to Mwai Kibaki. And when Mwai Kibaki came to power, he came to power on a wheelchair. He had a very bad accident that had put him on a wheelchair. So he came to power as a president on a wheelchair. And we took advantage of going to talk to him and to tell him about persons with disabilities and the needs and the concerns that they had. And from that time, within a year, the bill that we had already completed in 1996 was taken to Parliament and became law. This bill established the National Council for Persons with Disabilities, which was to actually implement the rights of persons with disabilities as in that bill. We have moved, and that's how, even when the ad hoc committee was formed, we had a very strong representation at the UN in the negotiation of the CRPD. And the Council has continued to play this role together with the United Disabled Persons of Kenya. We have formed what we call a caucus on disability rights advocacy, and we are pushing to ensure that laws that come out have a consideration of persons they are inclusive of persons with disabilities and their concerns. We are in the process of amending the first law that came, it was Persons with Disabilities Act of 2003, so that it can incorporate issues of the convention and the new constitution that Kenya came up with in 2010. This has been a long journey and a long process. We have struggled a lot. We have taken more than 10 years again in that process, but we are hopeful that we are soon coming to an end to this. But most important is the fact that the movement, the disability movement, has been very, very instrumental in the implementation of any law that has come out that has issues on disability. During our review, the review of Kenya by the CRPD in 2015, we had a big delegation of organizations of persons with disability. And when we came back to Kenya, we realized that the government was not taking the concluding observation very seriously. And we decided to call the government into a meeting with us and to agree on the process that we were going to use. We came up together with the government, with a working group. We came up with an action plan for the implementation of the concluding observation, and we have been proceeding on this. It doesn't mean it has been all that rosy. Many of the things that we want and we would like to say don't happen. But the good thing is that for now, many years, nearly 20 years, there has been very close cooperation between the disability movement and the government, and also other agencies like the Kenya National Commission on Human Rights, the Gender and Equality Commission. They all have programs on disability, and we work very, very closely together. We are not always on the same line, but we often agree on common areas of concern and common areas of advocacy. Thank you very much.
Thank you very much, Mr. Kabor. Just a request that participants, and we need to see you, even me, need to see you. So we're asking if you could lift the... we're not seeing, we're seeing it from your shoulder down, not your face.
Oh,
we want to see your face.
Oh, great. And now?
It's better now? Okay.
You can see me.
Sammy, you're not looking at the screen.
I am.
Okay, in the meantime,
Yes.
yes, in the meantime, I want to thank you, Mr. Kabor. Very good presentation again. Very good presentation. And you have some similarities to the experience of Mr. Ricer. And what came out in both, and yours, even it's more obvious, is the lack of political will to get the things done. While persons want to do it, the political will is often not there. And you have, which you did, to lean on persons who you think are best able to listen and to make it work. Disability bills, disability policies tend to take so long to be implemented because I believe that it is a lack of political will. You also pointed out that you are doing the revisions and so on, and I'm sure eventually over time, as time progresses and things evolve, the disability bills, regulations, and all those documents that we speak of will have to be revised to keep up with the times and how persons now view themselves. Initially, persons were seen, as Senator pointed out this morning, under the, we were made to be looked at under the Welfare Act, only the medical model. There was no human rights approach to it, but now the younger people have learned from us that the human rights model, and are learning from us that the human rights model is where we need to go. And once this is taken on, there will be changes to our legislations. Thank you very much. And I will now go to our final presenter, who is not with us. She is in Australia. And we have a video presentation. Let me introduce Miss Rose Case. Rosemary Case, sorry, I'm shortening her name. Miss Rosemary Case. She is an accomplished human rights lawyer, researcher, and academic. She has devoted her career to studying and promoting human rights and discrimination law in Australia and internationally. She is currently a teaching fellow and senior lecturer in the Faculty of Law at the University of New South Wales. Ms. Case was appointed to the Australian government delegation responsible for drafting the Convention on the Rights of Persons with Disabilities. She is currently chair of the Australian Centre for Disability Law and has advised the implementation of the convention in Australia, the Asia Pacific, and Europe. Now we'll hear from Ms. Case.
Hi. Today I've been asked to speak about legislation to protect people with disability. I will provide a broad overview of the Australian Disability Discrimination Act, or the DDA, and discuss the positive aspects of this legislation, but also consider the shortfalls in its application. Australia is a federal system with a national government, 6 state governments and 2 territorial governments. All 9 jurisdictions have enacted some form of anti-discrimination legislation that covers people with disability. This legislation has developed over a period of about 20 years, between the mid-1970s to the mid-1990s. Prior to the enactment of the federal DDA in 1992, people with disability had few and limited avenues to prosecute discrimination. And at this stage, not all state jurisdictions covered the ground of disability in their anti-discrimination laws. Australia has few human rights protections. We are the only common law country without a legislative Bill of Rights or a Human Rights Act. There are limited rights enumerated within the Constitution, and any other human rights protection, either statutory or common law, are piecemeal. The introduction of the DDA was seen as a watershed moment, and as with most bright new things, the DDA was highly anticipated and had great expectations placed upon it. But what did the DDA give us? Officially, the DDA objective is to eliminate discrimination, and it is to achieve this through an individual complaints mechanism, providing remedial compensation, including damages and policy reform for people who have experienced unlawful discrimination. The DDA covers both direct and indirect discrimination and includes the failure to make reasonable adjustments, sometimes known as reasonable accommodation. Direct discrimination is less favourable treatment because of disability or the failure to make reasonable adjustments. Indirect discrimination is when a person with disability is required to comply with a policy or condition that they cannot comply with because of their disability, and the failure to provide reasonable adjustments. The DDA covers discrimination on the ground of disability in specific areas of public life: employment, education, access to premises, provision of goods and services, provision of accommodation. Clubs, sport, incorporated associations, sale of land and administration of Commonwealth laws and programs. The Australian Human Rights Commission administers the DDA. It receives and investigates complaints, conducts mandatory conciliation between the parties, with litigation through the federal courts if conciliation is not successful. The drafters of the DDA attempted to balance the onus on individual complaints, acting as the catalyst for reform, by incorporating systemic mechanisms into the regulatory framework. These systemic mechanisms include A, powers to develop DDA standards in the area of education, transport, access to premises, accommodation, and the administration of Commonwealth laws and programs. These standards provide clarity and implementation measures for duty holders to meet their DDA obligations, and they can form a defence against complaints. B, voluntary action plans that can be developed by government and non-government agencies, businesses, education providers, and other stakeholders. These action plans aim to proactively identify and eliminate discrimination. C, powers for the Australian Human Rights Commission to undertake inquiries into areas of systemic discrimination and provide a report to Parliament. Whilst the DDA was not a panacea for the discrimination experienced by people with disability, it has, however, had some very positive achievements. From the beginning, the DDA has provided very prominent recognition of the discrimination that people with disability experience. The very symbolic nature of just having a law that prohibits discrimination on the ground of disability was very significant at a time when people with disability were still very much missing from public and political discourse and had very few options to pursue the discrimination they faced. The appointment of people with disability into the leadership role of the Disability Discrimination Commissioner challenged stereotypical notions of people with disability as being passive objects of social welfare, as opposed to being experts in law and public policy and active participants within our community. Much of the discrimination experienced by people with disability was structural, where systems and policies based on stereotypes, misunderstanding and fear created systemic barriers to accessing all aspects of community life. The early discrimination cases under the DDA were key in laying the foundations for reform, particularly in the areas of access to premises, public transport, education, online information, and telecommunications. One of the major successes of the DDA has been the cultural and legal shift in understanding that formal equality often results in discrimination. That treating someone the same doesn't always equate to substantive equality. There is now an understanding that we need to move beyond treating everybody the same to recognising that people with disability experience barriers, and the removal of these barriers is critical to achieving equality. Policies of general application are not always fair. There's now an understanding of the nuance of indirect discrimination and an acceptance of the requirement to provide reasonable adjustments. Where the DDA has succeeded over many similar laws around the world has been in its broad and flexible definition of the protected class. Whilst the definition incorporates a focus on an individual's functioning, its structure and application has essentially meant a social model focus. That is, where the interaction between a person with impairment and social and environmental barriers creates disability. The definition does not focus on specific diagnostic definitions. The underlying principle is of discrimination and disability as a social phenomenon. The legislation is directed at the phenomenon of disability, not the taxonomy. A more prescriptive medical definition would generally require diagnosis in the context of conflicting medical opinion. This flexibility of the DDA has meant avoiding the US experience, where the question of whether or not a person is a person with disability for the purpose of the Americans with Disabilities Act, the ADA, has provoked significant levels of litigation and has required significant amendments to address this. Whilst appearing quite medical and technical, the DDA definition covers the broad spectrum of impairment, including imputed impairment. As such, it focuses not on the pathology, but the phenomenon of disability. One of the significant benefits of this definition is it does not rely on the labels physical, sensory, and psychological that are commonly found in other domestic anti-discrimination laws. It is also generally the case that any particular disability is likely to fit within more than one of the categories listed. This expands its potential to be inclusive. Like many shiny new gadgets, they don't always do what you expect them to do, and the DDA has been no exception. The DDA's systemic mechanisms, the standards, action plans and inquiries, have had mixed success. The standards and action plans are largely voluntary mechanisms and rely on the commitment of industry, businesses and government to implement and drive change. Where elements of the standards have been mandated, there has been success, but this has been minimal and only in one area, access to premises. Action plans are entirely voluntary, and inquiries only provide a report that is tabled in Parliament. This places the onus on individuals with disability to lodge complaints in an effort to achieve an individual remedy and systemic reform. As an individual complaints mechanism, the DDA operates on compulsory conciliation. And if that's unsuccessful, it moves into the appellate courts at the federal level that are primarily cost jurisdictions. This presents a tough choice for individuals with disability who are unlikely to have the financial resources to pursue court action and where the potential of adverse cost orders is prohibitive. The DDA, in terms of statute, is beneficial legislation in that there is a legal principle that it is to be interpreted broadly and purposively. However, in the last 20 years, judicial interpretation has been narrow and technical, and this has left some parts of the DDA unworkable. This has been exemplified by two High Court cases, Purvis and Sklavos. In the Purvis case, a high school student with disability was regularly suspended from school as a result of outbursts that were triggered when he was frustrated. He was eventually expelled from his school, and his guardians claimed that the school had discriminated against him by failing to provide an individualised learning program to remove or reduce the triggers that caused his frustration. The DDA requires the court to compare the situation of the person with disability to a person without disability in the same or similar circumstances. This is called the comparator test. So while the court found that the student behaviour was a manifestation of his impairment, it also compared this behaviour to other students without disability who are disruptive and violent towards others, and found that he was not discriminated against. This has left the comparator test confusing and difficult to apply, and at its core, I believe, frankly, illogical. Purvis prompted legislative amendments with a degree of success, although there has been no judicial discussion or determination on how some of these amendments do or do not change the application of the law. The comparator test is still being applied in the same way prior to the amendments. In the Sklavos case, the court considered whether there had been a failure to provide reasonable adjustments for a person with disability who was required to undertake examinations for professional accreditation. The court found that it was not enough that the person with disability demonstrate a link between the failure to provide reasonable adjustments and their disability. The disability must be the reason for the failure itself. The consequence of this approach is that, for example, a blind person who requires software to assist them to undertake a task at work must show that the failure to provide that software is because they are blind. This has made the denial of reasonable adjustment unworkable as a form of direct discrimination. The lessons we have learnt from the DDA in Australia is that anti-discrimination law has a place in the policy framework to achieve reform, but it cannot be the sole driver. In 2022, the DDA will be 30 years old, and it now needs significant reform to address areas where it has become unworkable, to improve systemic mechanisms, and to take the onus off individuals with disability for driving systemic change. From my point of view, a better option would be for Australia to have a national Human Rights Act that incorporates all human rights and fundamental freedoms. Thank you for the opportunity to participate through this video presentation, and I wish you every success with the conference.
We thank Ms. Case for taking the time out to prepare her presentation, and it was extremely clear. And what came across to me, and I hope to the rest of you, was the fact that having the Anti-Discrimination Act, it's not good enough once it is not clear how you define discrimination. Because as she pointed out, it needs to be changed in her case to, in the case of Australia, to a Human Rights Act, because something like proving that, if she gave an example, that if a blind person is not given an equipment to allow him or her to work independently, that person now has to turn around and prove that why she didn't get it, it's because she is blind. So we have to be clear when we're constructing our legislation that the issues are clear, the definitions are clear, so that we would not have these challenges when discrimination does occur. Now we're open for questions. Thanks again to Ms. Rosemary Case from Australia. We have 15 minutes for questions. Anything in the chat? Okay, we'll hear from Dr. Morris, he has the first question.
I really want to commend both Richard and Sammy for their tremendous presentation. And, you know, I tell you, I'm so proud of you guys as my friends, and, you know, the depth of knowledge and information that you have on the community of persons with disabilities, and you have been using that to empower others with disabilities across the globe. And I have two questions for both Sam and Richard. Richard, I'm directing this to you because your country has had a long history of disability legislation. And I also note, based on global data, that the levels of employment for persons with disabilities significantly higher in UK than in developing countries. And also the purchasing power of persons with disabilities in England are significantly higher than those of developing countries. Do you believe that the legislative environment in the UK has contributed to that? Then I'm going to be directing this question to Sammy, because, you know, I have seen the work of the Kenyans, and I would want to find out, in terms of pushing the social agenda in Kenya, your legislation, would you say that it has contributed to the greater empowerment of persons with disabilities in your country in terms of creation of employment, in terms of access to education, etc.? Those two questions I'm directing separately to Sam and Richard.
Okay. I don't know if you want my video on. Someone needs to put it on if you want to see me while I'm answering. Thank you, Floyd, for that, and thanks for inviting me. We do have a higher level of employment than many areas. 53% of disabled people of working age are working, compared to 87% of non-disabled people. So there's still a gap of around 30%. It's also true that the jobs that disabled people hold are of lower grade, and that the pay gap is great, around 17%, and many more disabled people have unemployment. And there still remains over 3.5 million people, at least 1 million of them of working age, who want work, who can't get it. So there is a problem with employers' attitudes. Government have done some things recently to try and change that, but there's been very little shift in what's been going on. But nevertheless, with over half of disabled people of working age working, yes, we do have money in our pockets. And in addition to that, because we have disability living allowance, which is independent of whether you are working or not, which I think is very important, was replaced by personal independence payment, means that the extra cost of being a disabled person in the UK, you can apply for and get extra money. And this isn't small amounts of money, it is quite a substantial amount, amounting to up to £600 a month. That is in addition to working, and it is tax-free, which means, of course, disabled people do have significant amounts of money. There is still much higher levels of poverty amongst disabled people, and many disabled people are not eligible for these payments because of the medicalized rules that apply. I have sat on these tribunals as a disabled person, and you are with a lawyer and a doctor, and their views of disability are not our views of disability, and that's the problem. It is a medical model system. So while, yes, it's true that some of the legislation has meant that we are better off, there's still higher levels of poverty, particularly families with disabled children are at a much higher level of poverty than others, and there is insufficient recompense for that in the sixth richest country of the world. So we can't compare ourselves with Caribbean countries. We should be at a higher standard because we are a richer country. And there should be greater equality, and there isn't. And so those are some of the issues that we face, and we need to go forward to improve things beyond where they are. But it's called the Purple Pound in the UK, and it's worth about £300 million a year. So that's what we have, and therefore more and more manufacturers, marketers, and so on are looking to provide devices. More and more, and this applies particularly to the Caribbean, people who provide leisure facilities and so on are going beyond legislation and producing accessible structures and so on because there's money in it. So,
thank you very much, Richard, for your response. We have quite a number of persons in the chat. Thank you very much. Mr. Kabor, can you respond to the question Dr. Morris asked now?
Thank you very much. I hope you can now see me. Gloria?
Yes?
Yeah? Can you see me?
You want to know if I'm seeing you?
Yes.
Yes, I'm seeing your face now.
I can hear somebody telling you yes. Thank you very much. Thank you very much. This question about the situation of persons with, if I got it right, Maurice, about the situations of persons with disabilities in regard to livelihood, was that the question?
Floyd?
Repeat.
He's asking to repeat the question.
Okay, I wanted to find out. I wanted to find out, Sam, you know, how your legislation has contributed to the empowerment of persons with disabilities through education, employment, etc.
Thank you very much. Thank you very much. The establishment of the National Council for Persons with Disability came with its own packages, like the issue of provision of assistive devices. It's not all that good, and it specializes more on the devices required by people with a physical disability. But in the Constitution of Kenya today, which came up in 2010, and in which we persons with disabilities really participated and brought in a lot of ideas, provides that there will be a 5% representation of persons with disabilities in all appointive and elective positions. That is in the Constitution, but it has not happened 10 years. Nevertheless, there has been a great improvement in the conditions of persons with disabilities because on higher appointment now, there are considerations that persons with disabilities should be included. For instance, the Act on Gender and Equality Commission provides for preference of persons with disability as one of the commissioners. The same with the Kenya National Commission on Human Rights. Today, we have one judge of High Court and 2 judges of the Court of Appeal who are blind. No, one is albino and the other two are blind. And this is as a result of that provision of trying to bring in progressive realization of 5%. We have a permanent secretary, we call them principal secretary. This is the administrative head of a ministry who has a disability. And we find the presence of these people in their positions are very good ways of raising awareness to other people. We have some big companies that have targeted themselves to the employment of persons with a disability. And this is not just because of the law, but also because of the advocacy that has been taking place. Because laws can be papers on the shelves if they are not followed with very strong advocacy for the implementation. In education, we came up not so long ago with the
1 minute.
Learners with disabilities policy, and that policy brings in the whole question of inclusive education. This policy came up in 2018, and so we are still pushing for its implementation. So Kenya is not a heaven, but we are not where we were 20 years ago. We are moving on, but much, much more needs to be done. We need to be stronger in ensuring that even old laws are amended to include issues of disability. Gloria, give me just 1 minute. You see, the National Council of Persons with Disabilities has a program we call cash transfer, but this is only for people who are severely disabled. That means people who need care, who need constant care, they are given cash transfers. Other people with disabilities don't benefit from that cash transfer, and they have to rely on their parents or on anybody else. However, those people who have an income, those who have an income from their employment, they are exempt from paying income tax, and that is part of the laws. We have also managed to say that people with disabilities start
Time is running out on you now. Sorry, I have to.
This is the
sorry,
last
Mr.
point.
Kabor. We have a number of. Okay.
This is the last point, Gloria.
Yes, okay.
We say people with disabilities begin their life late, and after retirement, they hardly have anything else to do. And so the law has also changed the retirement age of persons with disabilities to be 5 more years voluntary, 5 more years above the normal retirement age. And we find that also part of the laws and again in the laws. Thank you very much.
Thank you very much for that information as well. We have a few minutes, and we have people, a number of persons. We're getting feedback. So a number of persons. So we're going to ask the persons to be concise in their questions and ask the presenters to do the same in their response, just to ensure that we facilitate those who want to ask questions.
Okay.
Who was the first one?
So this question was, this question from Haiti, I think it is to Samuel. How were you able to achieve cooperation from the government? I think it was based on the challenges that were being experienced. How were you able to achieve cooperation from the government?
Thank you very much. As I had said, we had struggled over a long time, and we had combined comparative approach at the beginning. That was our way of approach. But later on, we started looking at people with position who can be listened to the government. Like I talked of the Attorney General. We also took an advantage of a president who is in a wheelchair to make him understand our difficulties. But more than that, a lot of us went to school with some of the people who are now in position. And so we have also used a lot of diplomacy. And we think this has helped. But as an organization of persons with disabilities, we have had to design our approaches, and we approach each issue as it comes. It's not always the same formula, but approaching people in a position who can listen to you is one big way of getting into government. And if you listen to the president, everybody else comes and listens to you. So those are some of the approaches. But remember, we have not always been successful, not in all cases, but in quite a number of cases, we have used that approach and it has worked for us. Thank you.
Thank you.
A second question. In the case of Australia, where the court...
Australia is here to answer.
Okay.
Unfortunately, we can't take that question because the presentation from Australia was by video, was recorded.
Yes.
Okay. Next question. Based on the legal framework for the provision of reasonable accommodation, who is responsible for undertaking the cost of providing reasonable accommodations for students at the tertiary level? For example, if a university, private or state funded, accepts a student who is deaf, who is responsible for the cost of an interpreter? And it would be good to hear responses from the different countries.
Richard, you want to take first, and then we'll hear from Mr. Kabu on that question.
Yeah, we have in the UK something called a disabled students grant. It's recently been reduced, and the amount of sign interpreting that can be accommodated on that has been reduced. And it would then be for the university to fund the balance. If a university enrolls a student, they would have a responsibility to provide the cost of the reasonable accommodation. All universities have a disability advisor to support the students. And so it's a combination of the disabled students grant from central government and the university providing it. And the more the university goes towards a more universal design approach, the less they would have to provide reasonable accommodations. And so there's quite a lot of pressure on the universities to incorporate good practice on inclusion and access in their practices. But at the end of the day, it is still the university that has to do it. And similarly for examinations, amanuensis and anything else that is actually needed. We've had a lot of kickback from lecturers, but I think there's been quite a lot of training of them and they now accept it generally.
Yeah, in Kenya, we are different because, you understand, we are not a developed country and we don't have this kind of a fund. We don't have a student fund as such. But what has been happening lately, the issues of sign language interpretation remains a major concern. But other equipment like a computer with a screen reader program that now can be supplied by the National Council for Persons with Disabilities. They are not able to supply everybody, but they are supposed to supply, and other equipment that are necessary for students as part of reasonable accommodation. Braillers and things like that can be supplied, and that is a very recent issue. Before that, when I went to school, When I went to the university, there was an office here for the Commonwealth Society for the Blind, and they used to donate this equipment for us. And that went on for a long time. We became many and they could not supply. And so the coming in of the law provided that the Council for Persons with Disabilities should supply equipment. And we see equipment as part of that reasonable accommodation, particularly for students at the tertiary level of education. Thank you.
Thank you very much, Mr. Kabur. The responses from both of you indicate that in Africa, in Kenya, you have made some strides, but there's still more support needed. More support is needed in the UK as well. But I like that fund that you spoke about, Richard. Boy, we need that here.
Yes,
we need it badly. We need it badly.
Could I just say, in schools, there's less doubt. The school has to provide it, and the state, the government must provide it by a certification assessment system, additional funding for the needs of the child. So there's little doubt on the school system in the UK.
Oh, okay.
And I also ask you, Richard, what happens to those who go to private universities?
Okay. All right. Oh. Go ahead, Richard. Last statement, and then we have to wrap up. Definitely. Okay. We have gone over time. Go ahead, Richard.
We don't really
have... Go ahead, Richard.
Okay, let me see. Yeah, we don't really have private universities in the UK. They are all of them are, you could say they're all private, but they're also all state funded. And the Disabled Students Allowance applies whatever type of establishment it is.
Okay, thank you.
Okay. I want to thank you both for a very, very interesting, not you both, I want to thank you both and Ms. Case for very interesting presentations. We have learned from it, and we recognize that some of the issues you have, we do have it, and we hope that as time progresses, we'll be able to fix them so that persons with disabilities, the word discrimination will be history to person with disabilities, but we feel that it's going to be a long haul, but I think we're not discouraged. So I want to thank you, and I want to thank the audience, those persons online and those persons who are here with us. We want to thank you for sharing. Thank you for listening and participating.
Thank you.
I'll hand back now to our chairperson for this session, Dr. Christine Hendricks.
Thank you so very much, Gloria. She did an amazing job, didn't she? Yes, we can put our hands together for that session that we did learn so much about the experiences of other countries in the developed world, in our Commonwealth countries, on the implementation of their disabilities legislation. Okay, we're at the time now to take our coffee break because we are running a little bit behind. And so we will have to return at 11:30, where we will have the group discussions looking at the draft model legislation. I'm sure some other questions and discussions will come in that session. So we can leave the other questions for that time. So we will now take our coffee break. It is now 23 minutes after 11, and we have 10 minutes, and we will return. We're going to come back a little bit after 11:30, but I think 10 minutes is a good time. Thank you very much for those who are online. We look forward to seeing you in 10 minutes. Thank you.
Thank you too.
Okay.
White number, boy.
Is Joshua online?
Yes, Senator.
Joshua, give me a
Yes,
call now, please.
Okay.
Call me on my cell now.
Okay.
Just indicating to members in the breakout room that we're just having a little technical delay. Just give us 5 minutes and we will start the process, all right? Sorry about that. Joshua?
Right. I sent it.
Yeah, we need to restart and we need to get the poster off the screen.
No problem.
We can't find Devante. You can take it off?
Yes, he just did.
Okay, all right.
All right.
Okay, so we are now ready to resume. Good day, everyone. Having resolved all those technical glitches, we are now ready for the exciting session where we'll be focusing on the template for the specific legislation for persons with disabilities in the Caribbean. We will look at the adequacy of the template, what are the shortcomings, what needs to be added, and some specific recommendations for improvements. We will go into breakout groups and then return to the main conference in 1 hour. We will have a chairperson for this segment, who is Mrs. Charmaine Daniels. She is the Executive Director of the Digicel Foundation. She has been with the Digicel for over 10 years and has been the Executive Director for the foundation for approximately 3 years. She has a passion for persons with disabilities and has been leading Digicel's response for greater inclusion, participation, and non-discrimination of persons with disabilities in Jamaica. Let us put our hands together as we welcome Mrs. Charmaine Daniels. Just one more minute. For the facilitators of the room, you should expect to see Gloria Goff, Christine Hendricks, Tamisha Powell, Nicola Barker Murphy, Kerry Ann Ifill, Sharmali Camera, and Delane Fraser. One of those persons will be in your breakout room, in which you will be placed shortly. Thank you very much, ladies and gentlemen, Mrs. Daniels.
Dr. Hendricks, thank you so much. Ministers, permanent secretaries, attorneys general, committee members, members of the community of persons with disabilities, a pleasant good morning, I think it's still morning, to you all. It is my honor to participate in this conference in general and to chair this session in particular. Digicel Foundation and Digicel Group have been a long-standing supporter and advocate of persons with disabilities. We have been invested in the education of persons with disabilities, and we have been employing persons with disabilities. Overall, we have been practicing inclusion, participation, and non-discrimination of persons with disabilities. This conference, therefore, fits within the strategic mandate of the Digicel Foundation and the Digicel Group, and we're extremely pleased to be associated with this conference. The theme for the conference, Securing Participation, Inclusion, and Non-Discrimination of Persons with Disabilities Through Legislation, is really appropriate and fitting for an occasion such as this. If persons with disabilities in the Caribbean are to be meaningfully included into mainstream Caribbean society, legislation is fundamental. This conference, therefore, is very important to the transformation of persons with disabilities in the Caribbean as it seeks to establish a template for specific legislation to protect the rights and dignity of persons with disabilities. In this session, we're going to discuss the template that has been developed by Senator Dr. Floyd Morris and his team. We're going to go into breakout groups, as Dr. Christine just explained, and all persons have been assigned to groups. Participants will discuss the issues under the guidance of a facilitator and a note taker. Please make your views clear on the template, and upon completing the discussions, you will return to the main session for continuation of the dialogue. Once again, Digicel Foundation and Digicel Group are very pleased to be associated with this conference, and we thank Senator Dr. Floyd Morris for his guidance, and we wish him and the conference all the success. Thank you for having us.
Thank you for your support.
You didn't turn on your mic? Yes, please.
Hello? Hello? What is speak? Huh? Hello? I'm unmuted, but I'm not hearing anything.
Hello? Is anyone hearing me?
Hello?
Yes, hello.
I am on the, you know, I'm not hearing through the headphone. I mean, hold on. Hold on.
Yes, I'm hearing you.
Hello?
Hello. Good afternoon. I can hear you clearly.
Good afternoon.
Good afternoon.
Yes, from Antigua and Barbuda, we noted that we're going into sessions now, but we have another meeting actually that we have to deal with. So we'll not be able to
get some feedback. Hello?
Hello, we can hear you.
Hello? People are leaving the meeting because they're not hearing anything.
Hello, can y'all hear me?
Yes, if I can hear you, does that mean I'm in a group?
Yes, you do. Yes, you are.
Okay. My name is Paula Hender from Belize.
Welcome. I'm
you.
Carrie Ann Eiffel from Barbados. I'm using a cell phone, so hence why I don't have my video up. But
So
let me see who I have on this list.
Hi, I'm Desiree Clark. I'm from the Bahamas.
Okay, hang on. I see Desiree R. Clark. Is that you? Paula
Yes,
Hender.
that's me.
Okay. I see a Miss Gloria Goff. I don't know her at all. Never meet her in my life. I see a Sharmali Cardoza. Right, Miss Beverly, Miss Gloria. Antigua and Barbuda, I believe you said you're leaving.
Yes, we actually have a meeting that is conflicting with this one.
Okay, no problem.
Yes, we have to step out, but we did in fact look at the outline, the legislative outline already, and we did some comparisons. So I don't know if there'll be an opportunity for us to send feedback later on.
Did you please? Have you made any notes on any concerns or anything like that?
We discussed it. There's more than one of us on this meeting. So yes, we did discuss it from the legal perspective. We have had the opportunity to discuss it.
Okay.
I don't know if maybe later on we could meet and have that done. But we'd be happy to send our comments. We tried to stick as close as possible to the Convention on the Rights of Persons with Disabilities.
No problem. Thank you.
Yes. So that's what we wanted to state. So thank you very much. And
you're welcome.
Enjoy the meeting. Okay, bye-bye.
Thank you. All right, who else do I see? Militia. Please, I do hate mispronouncing persons' names. So if I do, please come in. I see Ricardo Banwari, and that is from Guyana. Are you here? I see an S. Hopkinson, and this is, I just say it marked as a device. If you could identify yourself. Sharmali, you're with me?
No, I should be one of the facilities, but I think they're still breaking out the room.
Okay, so that means I don't even know which room I'm going to be in then.
Right, because I think they're still placing person in the room.
Okay, because yeah, we're down to 28 persons. How are you, Sharmali?
No problem.
Okay. All right. Vivian Blake. We can only wait patiently until we're all appropriately assigned, I suppose.
Anybody hearing me? Yes, Gloria, we're hearing you. All right. So I was hoping I'd be hearing you through the headphone because we're all in one room. All right, but let's see. We're not having a feedback. All right, let's see. Let's go. You know, we were hearing it with a headphone, though. We're hearing it all the time. Oh, you weren't hearing us. Oh, okay.
Sharmali, oh, join break. Okay. Join. Is there anybody here? We are having some serious problems in my breakout room.
Okay, Diane Jennings, Technical Director.
Hello. Technical support.
Yes, may I ask what the issue is that you're having?
The issue is if you could make me a co-host, because somebody in our room, their mic is unmuted and they're having a very loud conversation and nothing we're doing. We can't get their attention to mute and we don't have permission to mute them.
All right, I'll make you the co-host now.
Okay, and how do I get back to my room?
All right, so I just made you co-host.
Good, thank you.
Do you see an option to join breakout room?
All right, hang on, I'm looking. Not at the moment. I'm in the breakout room with Sharmali Cardoso. Can you put me back in that one?
All right, you should see an option at the bottom for breakout rooms where you can join the one that you were in before.
Hold on, I'm not seeing it. I'm not seeing, oh, good grief. What is this?
Do you see a more option at the bottom of your screen?
Yeah, it's in there? Okay, got it.
Yes, click on more and go to breakout rooms.
All right, I'm all over it. I see more and then I see more again. Hang on. Background, language, disconnect audio, raise hands. I don't see breakout rooms in my more options, my friend. I see chat, video transcript, meeting settings, meeting, background, language, disconnect audio, raise hand, clapping hands, blah, 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 blah.
Okay. I'm trying to see if I see an option where I can add you manually.
If you see an option mark, more options on your screen, I take it you're using a computer, right?
Hi, carry on. Which room were you in?
I don't know what it was called, but it's the one that Sharmali Cardoso was in.
Okay.
The one that she's in.
All right, let me see if I can move in.
Thank you.
Yes. Yes. All right. So we have two options. If you want me to
Ah, excellent. Hello?
All right. Do you see the option for to join the meeting?
Yes, I do. I do. Thank you. I'm off.
All right.
Okay. Bye-bye. At least I will be as soon as it stops moving around. Where did it go? Oh, no, it's moved again. Where did it go? Where did it go? Okay, join breakout. Got it.
She's going to be running to
Miss Eiffel, you are okay now?
Yeah, she left the meeting, Mr. Morris.
By the way?
She left the meeting. She's okay now.
Okay.
Jamaica already has its own legislation on representation.
For the persons in the main session. Hi, for the persons in the main sessions, I have placed you guys in Carrie's Eiffel room. I'm asking kindly if you could join the pop-up once it comes on your screen because there's no one in her room. So the Barbados delegation, I'm going to be placing you in Carrie's Eiffel group. You should see a pop-up now. Let me know if you have received same. All right, great. The Barbados delegation is now in Carrie's Eiffel room. So let me just move. Felicia. Felicia, did you see a pop-up on your screen, or Tiffany, to join Carrie-Ann's IFA group? Tiffany Thomas Brown? Desiree, I'm not seeing where you joined the group that you were supposed to join. Hold for me. Hi, Desiree. All right, so she now went to her group. Tiffany Thomas Brown. Tiffany, Felicia, and Permanent Secretary Carol, you are supposed to be in Carrie-Ann's IFA group, but I'm not seeing where you joined. Hi, Carrie, I'm just checking that all is well in your group. Is this person it on? On.
Madame Swanet Désir.
Oui, allô? Allô, vous me recevez? Allô? Allô?
Un instant, Madame Swanet Désir.
D'accord, donc vous me recevez alors?
Oui, très bien.
D'accord. Hello?
Hi, Paula. Can you hear me?
Yes, I can. I think I got bumped off of my group.
Which one were you in?
Miss Hendricks.
Okay, let me put you back there.
Thank you so much.
Please note, all facilitators and note takers, we have to close the breakout rooms now. A note was sent that we end at 1:15. Thank you.
Welcome back to the main sessions, everyone. We are gathering the notes to resume at 1:30, after which we will provide a report from the group discussion from 1:30 to 2. We'll break for lunch at 2 and return at 2:30 to continue with the rest of the program, which is the discussion on the outcome document.
Ce qui a devenu le document, le rapport sur le document.
Okay, welcome back, everyone, after such scintillating discussions on the draft model legislation. I am sure you enjoyed that process. It was stimulating to the mind. And so we are now going to be doing some wrap-ups and guidance as to how we will proceed for the rest of the afternoon. So now that we have completed the group discussions, we are taking a 15 minutes break, within which time the note takers will have the opportunity to put the reports together. And then we will return at 1:30, I'm told. No, it's 1:25 now. So in 15 minutes we return. So that sounds like 1:40. We will return with the reports, which will take place for half an hour, and then we will go to lunch. All right, so we're on a 15 minutes break to put the notes all together, and then we will return to hear what everyone had to say. I do look forward. So see you shortly. Thank you very much. Okay, welcome back to our session. I do apologize for our late start as we were seeking to collate all the information received from you. We do thank you so very much for your input. And now we're going to be having the reports from the different groups, and that will be provided to us by Ms. Pamela Archer, who is coming to share with us at this moment. She is the coordinator for the conference. Very hardworking young lady. We do appreciate the work that she has put in to this process so far. So, Ms. Archer, it's over to you. Thank you. With the virtual space, it comes with technical challenges. And so we are seeking to work through the glitches, and we will get to you in a very short period of time. Thank you.
All right. All right. Hold on. There's some information here. All right. Yes. Good afternoon, everyone. I don't think it's on. Okay. I apologize for the delay, but as we say, we know within the virtual world, there are technical difficulties and we have to deal with them sometimes. So based on the discussion, this is the report for the draft legislation as it relates to privacy. Provisions are made for a database to allow to collect disaggregated data specifically focused on persons with disabilities as without data, it is not possible to plan. This agency would ensure that the rights of persons are protected. So it is suggested to include that it is suggested that the document includes specific content on women and children as well. As it relates to that, there is content on children with regards to learning plans and protecting their rights. However, it is explained that legislation should be ample and applied with equal and no barriers. All persons with disabilities should be considered equally in this legislation. It is stressed, however, that women face specific barriers, including domestic violence against women, which was increased in times of COVID. Thus, additional protection should be considered for women due to the possibility of domestic violence and should be included in the draft legislation. This can be included in the social protection component or on the provisions on security, support for women or persons who are victims of violence. How to address special accommodation or special planning for persons with disabilities in emergency and disaster planning and response. This has not been precisely covered, but it is a very pertinent observation. So that should be included in the legislation as well. Having disaster preparedness and response as separate heading would be useful in light of COVID. Special provisions. Special provisions regarding climate change and environmental issues, especially for future climate risks, should be made. Thus, how to address specific risks that may arise and how these can affect persons with disabilities. Social protection mechanisms. Under point 20, social protection should include welfare support for the caregivers of persons with disabilities. This was open for interpretation. Social protection should also include welfare support for the use of persons with disabilities who will require financial support. Depending on the circumstances, it will also include caregivers who would receive the funds on behalf of persons with disabilities. The legislation must take into consideration the varied challenges of parents of children with disabilities with the view of providing income tax relief for these individuals under strict conditionalities. This might be difficult to apply as parents might leave their jobs, be employed to take care of their children. In many cases, this is also single-headed households. This means that families rely on grants for support as they are not generating income. On point number 15, promote that all students with disabilities can enter the regular school system, but some have extreme disabilities. Therefore, provisions can be made for students that are not able to be in the mainstream education system. That is for children that need specialized education. It is suggested to expand point 15 with an additional paragraph to include specialized education institutions. Therefore, if students require specialized education support, it should be ensured that those education centers are staffed adequately in terms of resources, cognitive stimulation, affordability, specific individual learning plans, and curricula, etc. Clause to avoid putting children who can be in the school system in the specialized institutions. So that should be added, a clause should be added for that. Insofar as possible, children should be part of the mainstream education system. As it relates to rights to life in a hospital situation and also in emergency situations, for example, in COVID-19, there is limited supply or a crisis, discrimination can be made on disability. Everyone should get a fair and equal treatment and access to healthcare. This would be an additional break. As it relates to employment, persons with disabilities should have parity in access to employment, reference to assistive technologies, and reasonable accommodations should be included. And to expound on a little bit on as it relates to medical boarding, that this is available in Jamaica and Belize, and it refers to doctors determining if you can work or not. So this relates to employment as well. As certain countries do not have this term, it is agreed to indicate that if someone develops a disability, that the first option should be retraining and rehabilitation. As it relates to provisions on transport, universal access to transportation should be allowed and should be accessible to all persons, including signs in Braille and flashing lights. Considerations of specific service for the bus to pick up persons who are not able to go to a bus stop at their home and pick them up. This can be a mobile service. Also, suggestion to target transportation for those persons who are not able to go to a bus stop. The definition of persons with disabilities versus disabilities. There are multiple definitions. Definition should be in line with the UN Convention, including definition for persons with disabilities. In section 5, the last sentence in section 5, question within the statutory agencies. The question relates to, is the intention to create inspectorates or inspectorates to monitor? So then some clarity is needed there. The logic is not to have multiple institutions working on the issues in order to avoid duplication. There is one body. This would allow to monitor compliance and inclusion and parity of services. Session closes, but after inputs will be provided. For another breakout room, their points are as follows. They noted that the template is considered adequate. Under what should be added, the points are proposal to add language on recreation/entertainment for persons with disabilities. They are often left out in these areas, and so this should be included, just as with education, health, etc. Also to be added, language for coordination for persons with disabilities in instances of emergencies, pandemics, etc. Thirdly, to be added, engagement of youth in order to ensure succession planning in these areas, as well as to increase public education and awareness among youth to support persons with disabilities. For this group, they noted that nothing should be removed. As it relates to a suitable time frame for implementation, no specific time frame stated, given the range of consultations required. They're requesting, however, that the aim would be to advance in the shortest possible time. For breakout room number 3, they noted that the legislation is adequate. The recommendations are as follows. The 2% can be taken from different areas and not specific to tourism. Time frame for resolution of problem or complaints. Job protection for persons with disability. It should not discriminate because of their disability to assume per certain position. It should also be ensured that persons are not discriminated against because they become ill in the work world, for example, educating persons. Reviewing the legislation to ensure it is updated. The template should be developed as a full draft legislation was done with the family suite of laws developed by the OECS Commission. With this draft, ministers with responsibilities can edit and then forward to the Attorney General's chambers for finalization. Alternately, if a draft is not possible, then can a toolkit be developed where examples of the legislation from presenters over the past 2 days can be made available to member states to aid in the drafting of their legislation. This would address the challenge which, as it relates to the workload of the legal drafting team, which results in low prioritization to create full new legislations. And finally, a draft would allow for consensus or uniformity across the region. What should be removed? Change the word disability to impairment. As it relates to implementation, this group is suggesting that the legislation should take about 3 to 4 years to be implemented. For breakout room number 4, they noted that the legislation is adequate but needs minor adjustments. What should be added? Under purpose, add and for connected matters or issues. Also, what should be added? Critical groups of disabled persons should be represented on board of management, as well as creation of statutory agencies. What should be removed? Remove Anti-Discrimination Act and leave at Disability Act and give a year, give the particular year. Also to be removed, change definition to interpretation, as well as change language to encourage instead, for example, using the term must have. And legal representation should be changed to legal support where necessary. For another group, they're noting that the legislation is adequate. The broad headings capture everything, especially in the areas of education, healthcare, and housing. They did not provide anything to be added. However, they gave some information on a suitable time frame. So a suitable time frame for implementation. Time frame is now to implement this legislation. This was specific to a particular country, so I'll leave it out. It is recommended that we develop a scheduling for each country, because we have to take into consideration each country's funding and monetary issues. And 4, will there be an oversight committee for managing the implementation of this legislation for accountability purposes and to keep the countries and implementation plan in check? And that is what we have collated thus far. Thank you very much. We go back to Dr. Hendricks, our chairperson for the afternoon.
Let me say thank you very much to Ms. Archer for collating the reports from the different groups. I'm not sure if there are any questions or final comments. Okay, there is one in the room. Yes, and we'll interpret. Yes.
Okay. There was the section that dealt with linking, giving contracts, government contracts, and those persons should employ a person or persons with disabilities.
Not been heard properly though on the Zoom platform.
Can you come closer, Ms. Goff?
Yes, thank
we're
you.
taking a mic to you. Okay.
Okay. It's okay.
Can you say who you are and where you're from?
I am Gloria Goff. Yes, one of the issues raised in my group was that there is a section on in employment where it is suggested that persons' government contract should be pinned, I don't know if it's pinned is the correct word, but that persons who get government contracts should provide employment for persons with disabilities. And the discussion was that it would not be just that. It could be because there might be government contracts where you can't employ anybody. It can be a consultancy, or depending on the consultancy, you might not be able to employ a person with a disability. So it's not that they're in disagreement, but they're saying that it could also be that the contractor, one of the things is that the contractor could contribute to the disability fund in cases where they're not able to provide employment. Huh? She said it. Oh. Yes.
There are some issues that we have to look at in terms of drafting legislation, and that is why some of these issues are not placed in the template, because some of these issues would come either in regulations or come in codes of practice. And there are some for creating this template, we could have put in a lot of things, but it is a template that we are working with, and so countries now recognizing the government policy, recognizing the particular imperative, would plug in the information using the template as a guide, right? And so some of what is being recommended would be fit for legislation, but some would be fit or more appropriate to go in the regulations or to go in the codes of practice, which the document speaks to.
Okay, thank you very much for that question and that response. All right, having said all of that, I am not seeing any hand raised or any. Oh, somebody has a hand up. Quickly, please. Oh, Vivian Blake. Yes, Sir Blake. Open your mic.
Blessed afternoon, colleagues. Well, I just want to put on the table for discussion and I personally understand the usefulness of the codes of practice and that certain things have to be translated on the ground through the codes of practice. But I want to put that on the table for discussion, and especially in light of the Jamaican situation, where the codes of practice probably is one of the things that has been highlighted as affecting the passing and implementation of Disability Act. If it is that, because for example, all of the other sections of the Act are very relevant and could have been implemented from when it was passed in 2014 and all of that. So I just want to put that on the table for discussion. I don't know if I'm articulating exactly what I need to say, but that is one thing I would want to put on the table. The other thing that came to mind going through the legislation was when you see about the whole, and I know these are primarily examples, you know, in the whole incentivizing of the employment situations, etc. You know, one of the other things I also think that probably could be considered, you know, when we think about other disability-related services, we think about from the special education perspective, special education teachers. One thing to say that institutions must be adequately staffed, but we're not training enough teachers. So, you know, I just thought that, and I don't know, as Senator Dr. Morris said, how specific legislation can be about some of these things. There are more, you know, for the codes of practice. But I was just, that also aim, you know, about the consideration for the incentivizing of certain other things, such as the disability-related services that are not available and that realistically will not be available unless sometimes we put certain things in place. So those are the 2 points for further discussion.
All right, thank you very much, Vivian, for your useful question, comment. As it relates to the issue of the codes of practice and the implementation of the Jamaican legislation, I want to say that in drafting the template, upon examining the other pieces of legislation in the Caribbean, I realized that one of the strong features of the Jamaican legislation is the requirement for codes of practice to be established, because codes of practice supposed to be guides to help prevent discrimination against persons with disabilities in respective fields. And so we looked at that, and I must say commendations to Tamisha Powell, who worked with me on the document as well. But the point is, and the concern that you have is that the implementation of the legislation has been stymied by the drafting of the codes of practice, which in your estimation is unnecessary, and I think to some extent you find favor with me. And by the way, the Disabilities Act has been passed in Parliament. It is a legislation. It's not the codes of practice is not delaying the passage of the act. It is delaying the implementation of the legislation, which I think if I was responsible, I would adopt a different approach, because when you look at the legislation expressly state, that is the Disabilities Act, expressly state that you must have a code of practice for education. But it also states that the JCPD should formulate codes of practice. It never states the codes of practice that the JCPD should formulate, but it gives the authority to the JCPD. The conundrum that the ministry faces is that there is a new JCPD as a body corporate, a statutory entity that it anticipates formulating. And there is the view that the JCPD as is now does not have any locus standi. Sorry, Tamisha, I'm correct on that terminology. So I'm being a good law student. So they don't have any standing as is now based on the law. And so what happens is that the codes of practice have to wait until the new JCPD is established for that to come into effect. But I tell you, that is not the critical issue for the non-implementation of the legislation. The critical issue has been the regulations. If the regulations were formulated a long time ago, then it would set the stage for the JCPD to the new JCPD to come into effect, and then the new JCPD would be able to move along with the codes of practice. But I mean, we are where we are, and my thing now is to say to the minister, set the effective date for the legislation, because even though the parliament has seen the regulations tabled recently, there is not an appointed date that has been set for the legislation to come into effect. And I keep on saying to the technical team that they need to prepare the country for the legislation to come into effect. And so they would have enough time to plan for its implementation. So whilst you're doing this sort of legal legwork, you have a date in mind when it will come into effect, and people would be planning for that. So, I mean, as is now, the regulations are tabled in Parliament. Parliament is on recess. Come back in September. It will be debated in the House of Representatives. I don't anticipate, well, I haven't seen what is in the document as yet. I got the document, but I was busy preparing for this conference, so I haven't read it. And once that is debated, then the regulations come into effect. But you don't want the regulations to come into effect again, and then it is delayed because we are hearing that, we have to put in place measures for the new JCPD to be established in terms of staffing and all of that. You see, the government put money in place to fund the new JCPD. It is in the budget. It is in the budget. So I don't know what it is. So I mean, the conference is not being hijacked by the Jamaican legislation, but the question was asked by someone from Jamaica, and we had to respond. But it is important because we are encouraging codes of practice to be formulated by other jurisdictions to make sure that discrimination is prevented against persons with disabilities, because it has to be used as a guide.
Thank you very much, Dr. Morris. Vivian Blake, is your hand still up? You had asked your question already. You could remove your hand if you have nothing else to contribute at this point. Thank you so very much. Any other comment? We're wrapping up so we can go to lunch. Awesome. Thank you so very much for this session, which, as I had said before, was a very scintillating session that we delved into the draft model legislation, and we heard the report from the group discussion. We'll go to lunch and we return at 3 to discuss the outcome document with Ms. Tamisha Powell. All right, so enjoy your lunch, your lunches, everyone. and I'll see you back at 3. Thank you. All right, so we have half an hour, 40 minutes for lunch. Lunch is here, Mrs. Bennett?
Laura?
Good afternoon, everyone. Welcome back from lunch. I see we still have 45 participants, and we're hoping that the others will join us shortly. I trust you enjoyed your lunch and you're now ready for the final leg of our two-day conference. That's been really going great so far. Let me say thank you so far to all our participants, our presenters, and everyone that has come together to make this day or these 2 days possible. Now we're going to be discussing the outcome document. And we have Ms. Tamisha Powell, who is our legal luminaire, that's the word. And she will be taking us through. Ms. Tamisha Powell, thank you so much.
Thank you very, very much. Good afternoon. I promise I'm not going to take a lot of time. I will be reminded that brevity is the soul of wit, as Shakespeare said. So currently, 12 of 15 countries in the Caribbean have signed and ratified the Convention on the Rights of Persons with Disabilities, the CRPD, hereinafter. However, only 6 countries so far have established specific legislation to ensure the protection and non-discrimination of persons with disability. As you guys have already heard throughout the conference, it was mentioned yesterday that both the Kingston Accord and the Pétionville, the Declaration of Pétionville, which were agreed to in 2004 and 2013 respectively, required countries within CARICOM to develop model legislation to protect persons with disabilities. This, of course, is now a major concern as international law and specifically the Vienna Convention mandates that every treaty in force is binding upon the parties to it and must be performed in good faith. Arguably, therefore, the delay in the development and implementation of specific legislation to ensure protection and inclusion is a breach of the rights of persons with disability, as well as the breach by the respective nations of their obligations under the CRPD. The purpose of the guideline document that was developed is therefore to provide some assistance to a starting point with the development of local legislation across the region. We should never let a good crisis go to waste. I believe Winston Churchill had made that statement many years ago, and it is still appropriate today. And so in the context of COVID-19, if we have to rebuild in any event, let's rebuild the right way by rebuilding a world where persons are not disadvantaged nor excluded by virtue of their disability. Now, a foundation principle of law, which we still hold sacred to this day, is the rule of law. And at its core, the rule of law mandates that there should be a minimization of harm and unfairness in the application and design of laws and legislation. And I say here core because there's a lot of discussion there has been through the beginning of the inception of the principle of the rule of law with regards to its application, interpretation, and whether or not it should be procedurally based, or content-based. I'm not going to be going there this afternoon. But I wanted to borrow from Lord Bingham's conceptualization of the rule of law, as he has outlined in his book, The Rule of Law. And it says that the core of the existing principle is that all persons and authorities within a state, whether public or private, should be bound by and entitled to the benefit of law publicly and prospectively promulgated and publicly administered. And so out of that, he has 7 sub-rules. I will only be raising 4 of them, and I'm only raising them in passing. And these 4 are: 1, that your law should be accessible, clear, and predictable. And of course, when we talk about accessibility here, it is that it must be in all forms so that everyone in the society can indeed access the rules and the laws. And these are something that is often overlooked. It should be clear, which means that persons should be able to understand what they're required to do, what their rights are, and what their various obligations will be within the respective legislation. 2, the law of the land should apply equally to all, except where objective difference requires differentiation. And in this principle, the key term here is objective. And so it should not be someone else's interpretation of what you are capable of or why there needs to be a difference. It should be an objective measure that is used. And so this is where we look at the human rights model as the better approach with regards to the way forward with regards to legislation development and how we really ought to be restructuring our society, because the human rights model takes away a lot of the preconceived stigmas that we have with regards to persons with disability and attempts to apply a across the board objective approach to rights. The law must protect fundamental rights. That speaks for itself, as we would say in law, the matter speaks for itself, right? Res ipsa loquitur. The rule of law requires the state to comply with its obligations in international law. And this particular one is extremely critical because, as mentioned before, we are all signatory, or 12 of us are all signatory to the CRPD. And so now the time is now right, and we ought to be stepping in the right direction to ensure obligations are met. So while various scholars may differ on the tenets which define the rule of law, it is clear that where the legislative framework of a society is silent or have laws, the application or interpretation of which results in a disparity in its application, it is a breach of the rule of law and the rights of the individual. The important takeaway from the outcome document, therefore, is that any legislation that is developed must be geared towards the protection of the rights of persons with disabilities. It should make specific provisions for the social protection and provision of social services. It should ensure access to justice, access to participation, political participation. It should also ensure that there is some agency or body that will be responsible to ensure compliance, as well as the management of the rights of persons. When I say management here, it is ensuring that they have the access, that the relevant stakeholders are doing what they are required to do. And so many of these social rights have been ignored for a very long time and overlooked in the general discussion on the rights of persons with disabilities. The implementation of appropriate legislative protection is a hallmark, I would say, of any democratic society, and therefore it is critical. As has been noted throughout the conference, persons with disabilities are generally more vulnerable than their respective counterparts, usually not due to their own limitation, but as a result of the barriers that are placed along their pathways. Persons with disabilities are generally hampered by having to overcome the attitudinal biases and stigma that remain pervasive to this day, in addition to having to just generally live life. And I would argue that we are forcing persons with disability to run a race within a race. In the passing of the legislation, the recommendation, therefore, must be that we not only have social protection, but we have a statutory agency and a rights tribunal that will be able to provide an avenue for persons whose rights have been infringed to have it dealt with in a speedy way. The composition and funding is recommended. Should be included in the legislation, and this will ensure that the particular body is above the political will of any one or particular group and is entrenched in primary legislation and supported by secondary legislation. And this is very critical, as was pointed out earlier this morning in this session that Gloria had shared. Sometimes the political will is the determining factor for persons' right, and that ought not to be. The guidelines are providing what we want to consider a prescriptive approach as to how sections or how the legislation can be drafted or could be drafted, by identifying the needs for fundamental sections that go deep into establishing tangible change and the approach of how persons with disabilities are to be treated, and not merely a continuation of the state of affairs. While it is understood that law is not the penultimate or the final step in the real change, because there will have to be some social movement, I'm going to borrow from Ms. Gabriela Ramos, the Assistant Director General for Social and Human Sciences of UNESCO. She said this yesterday, I'm not sure if you remember this, but she said good legislation And good implementation is the basis of great outcomes. I thought that was brilliant. And that is really the reason that we are here today. And that is the basis for the document. It will not cure everything, but it certainly is the basis and the foundation upon which great outcomes will be achieved and actualized. I wanted to do that as a sort of preemptive introduction to our discussion topic. Before we went off for break, we had gone through the actual document itself. And so I don't think we necessarily need for me to go back through it line by line. At this time, I would be willing to field questions or get further suggestions from persons with regard to this discussion, how it is that we're supposed to move forward, and the rules, the implementation of it, and where it is that we see ourselves in the next couple of years if we fail to protect those in our midst who are the most vulnerable. I would say that we're failing in our responsibility as a part of a collective. Thank you. So I'm open to questions with regards to the document, if there are any. No?
Hello.
Yes.
Edmund Hickson, Barbados.
Afternoon.
Are you hearing me?
I am hearing you, yes. Good afternoon.
Okay. Yes, okay, Tamisha. I think that ultimately it boils down to political will. Do we, as a Caribbean nation, because I mean, historically we are all one, do we have the political will, or do our governments, respective governments, have the political will to provide the resources, financial, technical, and otherwise, to really give persons with disabilities the rights and needs that they deserve, like any other aspect of society? That's ultimately it. And what I tell the persons and the organizations that treat the disability issues in Barbados, a lot of it has to do with lobbying. And let me speak for Barbados, and as I said, as a politician. I don't believe that persons with disabilities and their organizations lobby their respective governments enough. And maybe they don't realize the power that they have, because invariably in all of our societies, persons with disabilities make up between 5-10% of the population, somewhere in between there, give or take. And when you add then those who look after persons with disabilities, are their caretakers, you add on another 5% of the population. So persons with disabilities and their caregivers make up a significant percentage of the people in all of our societies, and hold tremendous power in terms of voting rights. But I don't think that it is used to the effect it should be, because ultimately this is what it boils down to: making the governments understand that they have to commit resources to the cause. Because when I heard yesterday that, we do have 6 countries in the region that have passed the laws, but for one reason or another, I think maybe only 3 of our countries have proclaimed legislation and made it effective. And we're talking about you need the regulations to go forward. You haven't passed regulations yet. In other words, our governments have not committed themselves to advancing the cause. And this now, obviously, the last year and a half, where we've had to fight COVID, didn't expect it. So understandably, resources are into that. But there again, people with disabilities are more liable to be affected by COVID than any other sector of our economy and society. So ultimately, I think that this is the issue, the political will to commit to the cause. And if that starts, yes, by legislation, but as you correctly said, legislation is not everything, and it has to come with the financial and technical support to buttress that legislation. If not, we'll be back to square one. Thank you.
Well, sorry. Okay. One of the things, as you mentioned, political will, because we have spoken quite a bit about that. And I believe the big hamper to persons with disability really being able to make that sort of impact is whether we want to admit it or not, we have disenfranchised them from the voting process. And I say we've disenfranchised them because most persons don't consider very simple things in the voting process. So if I'm unable to see, I will have to have someone with me for me to cast my ballot. And sometimes you may have persons who prevent someone accompanying someone who is blind into the voting space because the principle is it should be a secret ballot, right? Sometimes where you're supposed to cast your vote, there's no wheelchair access. And so little things like that. I'm agreeing with you that absolutely there has to be a grouping and there has to be a position where persons with disability and those of us who know better, we need to start to advocate much, much stronger. But we have to also think of the reality. Have we tied their hands in participating in the voting process and then say, well, you haven't participated in the voting process? So that is something that I think we have to look at. And that is why part of the document, when we were preparing the document, it was very critical that access to political participation was so critical. Persons should not feel as though they can't participate. And even though we don't say it, your actions are, or I should say, our actions speak so loud that it's hard to hear what you're trying to say. So that might be something that we also need to consider.
If I could follow up, you're absolutely correct.
Absolutely.
I don't know, obviously, about the other Caribbean countries in terms of legislation. But yes, this issue came up when, we had our group discussion on the model draft, the ability to vote. And in Barbados, under our People's Representation Act, there is provision for voting for persons with disabilities, as you said, blind voters. And yes, I've heard of cases where, the person in charge of the polling station would tell them that you can't come in with somebody, and that the person in charge of the polling station can vote for you. Now that is a clear breach of our law, clear. And certainly I, as a candidate last election, would have sensitized all the people with disabilities who were going to vote for me as to their rights, and not to take that whatsoever. Title under the law to carry who you want in there and to tell them, I want to vote for X. Don't, because you're correct. I did come across people who previously said that, they didn't go to vote or when they reached and they were told they can't carry, X, Y, who they trust and have confidence in to vote. They didn't worry to vote. So like I said, I don't know what the other legislations have. I presume that you have protection in your laws. I was looking at the Guyana disabilities legislation, and they specifically mention this issue about voting by persons with disabilities. But again, this is something fundamental. How can you discriminate against someone for voting, something that we fought hard for, in the 1950s and 60s, the right for everybody to vote, you know, and as we know, only 30 years ago in some parts of the world, South Africa, people of all color got the vote. But yet you find people of your color now seeking to prevent you from voting just because you have a disability. It can't work.
Yeah.
And these are things, like I said, that, you know, it's all right for me as a politician to speak about, but also people with disabilities themselves have to speak, because and they hold a significant percentage, because 5%, and plus another 5%, they're caregivers. 10% will swing any election anywhere in the Caribbean if you vote en bloc. So that's why I raised that issue, that I would like, and you know, I say this, as I said, as a politician, I would love that people with disabilities stand up more against the government of Barbados, regardless of political party, and demand their rights. I mean, this is it.
Okay. Yes. No, absolutely. Thank you very much. Do we have any other comments or questions in the chat? But that is the crux of it. Yes, Ms. Goff.
Yes, good afternoon, Gloria Goff. It just came to mind, although I've looked at the document a number of times, I don't see a section on justice. And I know that in the Jamaican Disability Act, there is not a section on justice. Is it because justice is so complex, and so why isn't there a section on justice? And I'm talking about, you know, when you talk about, there are quite a number of issues that come out about the court system, the treatment of police officers, of persons with disabilities, especially in terms of deaf persons. How does the system treat with persons with disabilities? So I'm just wondering why. I see mention of justice, you know, but it's listed among other things. Why isn't there a section?
Well, okay, so that can be amended. It was collapsed into general sections that deal with accessibility or social protection. But I do take the point that perhaps there needs to be a specific pulling out, even as it relates to the establishment of this body, because one of the things I know we always have a little discussion with, and Gloria has been a part of some of these discussions, Gloria, so you'd be aware of what's in the room, where the issue, even as to someone who is deaf, who is responsible for the interpreter in court. So I do take that point. So because we always circling that mountain, which comes first, the chicken or the egg, almost sort of a thing. Is it the court management system who is responsible? Is it the police officer? Is it the person in themselves as a part of their own mounting of their defense or their own legal team that's supposed to be providing the interpreter? So I think that there definitely could be room for perhaps a section. Maybe it might not be standalone, but we could perhaps put it within the responsibility of the agency, that where someone is going to be brought before the court and there is a requirement for an interpreter, that one could be provided through them. That could be a way to treat with it. Sorry, yes, sir.
I have noticed in the Parliament, as Gloria asked the question, I was, by the way, Floyd Morris speaking for the members of the audience. I've noticed in my years of experience in the Parliament, going into 19 years now, legislations relating to the justice system are generally captured under justice-related legislation. I can't recall seeing a piece of legislation dealing with justice in, say, education or local government or so. No, man. I'm just talking. You're talking about access to justice, right? So I mean, but I'm saying that I don't recall seeing any legislation. Generally, they would want to have existing legislation that relating to the justice system amended to capture issues relating to disability. So for example, the whole issue of evidence, how you treat the issue of evidence in the courts as it relates to persons with disabilities. How do you treat issues of witness, you know, et cetera, et cetera. So, I mean, those things, I generally see it come under legislation relating to the justice system. And I think that we need to press for those legislation to be amended to capture the issues that we have concerns about, you know, so issue of training and so forth, right? And then the justice system is an area that there should be codes of practice for, right? Because it would cover how you treat a person with a disability who comes to a police station and makes a statement. What happens after that? You go to the court, how a person with a disability is treated, what are the considerations that should be made. You know, you have deaf persons who are in the courts, how those issues should be treated. If somebody with a disability is in the penal system, how that should be dealt with. Should there be some connection to the JCPD, that is the state agency with responsibility for persons with disabilities? We see persons with disabilities being in the system now and being lost. And if you have a tracking mechanism where the relevant state agencies, there are interconnectivity, then, you know, it would lead to all-round improvement. So we need to press for a code of practice for justice.
Well, it would be an amendment to it.
As well. So those are some of the issues that we need to focus on. So as I indicated this morning, and Tamisha and I had to contend with them. What are the salient issues that we need to integrate in this legislation? And we looked at we looked at a number of legislation across the Caribbean and how they treat different issues, and then put together the template. And we are saying that, you know, most of the countries in the Caribbean are sovereign states. And so they have their independence, and you have to guard against that so that we can't draft a legislation for them without them giving drafting instruction. So the most you can do is to create a template, and when they get the template now, is for them to plug in the information, and they are going to get experts to assist them in going into the specificities of the legislation. And so, you know, that is how it has to be addressed so that you don't transgress, you don't transgress the sovereignty of countries in the region, because you can't just impose legislation on the states without them making the particular request.
Sir, as you were speaking, I thought to myself, similar to how the Office of the Children Advocate works here in Jamaica, where within their whole requirements for their functioning, they are required where a child needs legal representation to provide one, and when a child is in a lockup, what ought to be happening. And so perhaps that could be the happy medium, that the agency, while you're absolutely correct, you may not be able to flesh out access to justice in a Disabilities Act or an Anti-Discrimination Act, maybe that's a better way to call it. Perhaps if the agency in their own incorporating or statutory document is required to do it, then these codes of practices, they would be required to develop where it is that amendments ought to be made to things like the Evidence Act, then yes, they would be the ones leading the charge, because it's been my experience sometimes that if nobody has the responsibility, it does not get done, right? If it's not assigned, right? But that was just what I was thinking while you were speaking, that could be a good way to capture it, similar to how we have captured it with CPFSA and the Office of the Children's Advocate. There's a hand. There's a hand. Yes.
Hi. Yeah, Edmund Hinkson again, Barbados. Yeah, Senator Morris is absolutely correct. I don't think that, you know, Pacific disabilities legislation can address all of these issues. It can't be all embracing. There's no perfection in any legislation. Clearly, there should be a broad statement about accessibility and equality before the law and justice system. But yes, I mean, issues such as prevention of a disadvantage before the law courts, etc., is determined generally by legislation specific to those like the Evidence Act in Barbados certainly speaks towards protection of someone who is deaf and giving them the right, to be accompanied by an adult, you know, and being questioned, just as you said, as a child has that right. But besides the broad principle, I don't think you could go off anymore in terms of disabilities legislation. What I said during our breakout session though is the Guyana Act speaks towards burden of proof, and that's a point that I would wish to you know, commend, that where an allegation of discrimination is made by a person with disability, once they make that prima facie allegation and case, the burden of proof then shifts to the person against whom the allegation is made. Now prove that there was no discrimination. And I think that is important because, you know, as we know, burden of proof is very important. And if a legislation has the ultimate, once the case is prima facie made, that the burden of proof shifts now to the other side to prove there was no discrimination, I think that is very helpful. And that's where I would want to suggest legislation can help persons with disabilities in terms of access to justice before the courts or tribunal. Thank you. Yeah.
All right, are there any other questions or comments? Okay. All right. Any other comments in the room? Questions? No? Okay. All right. Well, thank you. The comments that were given today during the breakout session have been recorded, and so the necessary improvements will be made. We thank everybody very much for the full participation, and we really do appreciate the willingness to go through and to contribute. So thank you very much, and we look forward to great things happening in the region in short order. Thank you.
Thank you very much, Ms. Powell, for that wrap-up discussion there, looking at the possibilities of this outcome document. I'm sure we all look forward to it. I see St. Kitts saying that they had to leave, but they're looking forward to the document and the report and the next steps. Okay. I see some comments here in the chat. One comment said it would be the different entities that the persons with disability interfaces with who is responsible to provide an interpreter. I think that's a different comment than what we've been looking at. So we are going to be running then to our final discussion for this afternoon, or final segment, and it is the commitment from Caribbean countries to specific legislation. Senator Dr. Floyd Morris and Ms. Beverly Reynolds from CARICOM will be taking us through this discourse. So Senator and Ms. Reynolds, thank you so very much.
Right. Ms. Reynolds, you're on?
Yes, she is.
You need to unmute your mic.
I always do that, you know, almost always. I forget to do it.
Great. Okay, great. So how we are going to proceed here. Ms. Reynolds is going to give some comments in terms of the from the CARICOM Secretariat and reaffirm certain comments, observations that were made, and the need to establish the disability-specific legislation across the region. And then after she makes her intervention, I'm going to be speaking to the issue of time frame, the issue of advocacy for the implementation of the legislation, and also to look at a mechanism for monitoring the implementation across the region. And just to indicate those countries that are online, those countries that are online, I would want you to type in the chat you know, express your commitment. I know that some of you would have to go to cabinet for decision and so forth, but just to express your commitment to working on the formulation of disability-specific legislation in your particular jurisdiction, and to also indicate what support that you would require from the Center for Disability Studies and the Office of the Rapporteur, because we are prepared to work over the next couple of years to sort of push and drive the agenda in this context. So that is how we would want to proceed. And I would want to ask Ms. Reynolds to lead out, and then I will take up from her.
Thank you, Dr. Morris. I want to begin by just really giving my congratulations to what has been 2 days of very rich, instructive seminar conference. And I want to commend you, sir, and the organizers, and also to thank all of the partners and University of the West Indies, DigiCell, the Commonwealth Secretariat, and UNESCO. I think the presenters that you brought in, not only from our region, but from the other countries, the other region, has really helped to ground for us. I believe that this is a struggle that's common to people with disabilities across the globe. And I am so very happy that this has been brought to the table. I recall as a part of the committee with respect to the implementation of the Pétionville Declaration, which you, Dr. Morris, has been mandated as the CARICOM Special Rapporteur to provide oversight for its implementation, advocacy, and so on. That one of the first things that you outlined in that very first meeting that we had was these activities, a set of activities that using that same declaration that you intended to pursue and to bring into fruition. And this is one of them. And this one is such an important step. So I want to commend you on that. Now, I think that as we've all heard, without legislation, the equity looking for will not happen. And therefore, this is something that when we discuss, when Senator takes us through the timelines, I hope it will be something that, I'm sure it will be something that's going to be doable and will take into consideration where the various countries are. Now, the one thing that I'd like to flag is that now we know that there are 6 countries that have specific legislation. I believe that the template that was provided is quite comprehensive. There are some things that we flagged. I've made some comments on that, but I think it's pretty comprehensive. What I think, though, would be necessary in going forward would be, one, that there is capacity building for both the persons who would be either a part of the commission or the board, and for those who would have responsibility in terms of the tribunal. But I think to be sure, to make sure that we move to that place of implementation so that we can achieve the goal of this very important conference, we want participation, equal rights, access, and the dignity that really belongs to each and every member of our society, persons with disabilities. I think what's going to be important, though, is that for the countries that have yet to do something in terms of the specific legislation, I believe it would be useful if we were to do some kind of assessment of where the gaps are for them. What are the institutional challenges that might be present? What are the human capacities and capabilities that need to be strengthened? So that once we now move into that phase of the implementation, we have a pretty good idea of what needs to be strengthened, what needs to be put in place. And I believe from listening to over the past 2 days, that the support that we'll be getting from the partners, and I'm sure there'll be others, that this would be something that they might want to consider supporting. I think it's important that we understand that. And then once we know that, we can begin to build the capacity to implement. But as I said, I really want to congratulate you, sir. I want to thank you and to take this opportunity for myself to say that indeed, as Director Royer had said, you have embraced this mandate of CARICOM Special Rapporteur on Disabilities. You have embraced it with a passion, with a zeal, and with a determination to make sure that what you have set out to do will be accomplished. I would like to say that in going forward, the CARICOM Secretariat is behind you 100%. I recall that Director Roy said that progress has not been up to the expectations that we had envisioned and we wanted. But you know, you said something which I want to call reference to. If we don't succeed at first, we come back again. And if you don't a second time and a third time, and it is going to happen. I have that confidence that there will come a time when our community of people living with disabilities will be enjoying access to education, access to health care, access, which, as was said earlier on, to build, not just access to buildings in terms of a ramp, but all the necessary processes, all the necessary tools, all the equipment that will allow them to enjoy their rights with dignity. I just want to stop there, but as I said, I want to let you know that the CARICOM Secretariat will continue to support this initiative and to support you in your office as CARICOM Special Rapporteur on Disabilities. Thank you, and over.
Thank you very much, Mr. Reynolds, for your reaffirmation and the observations that you have made. You know, colleagues, I want to say that I deem this work or this task not just as a job from the University of the West Indies in my capacity as director for the Center for Disability Studies, or as the rapporteur for disability from CARICOM. But I view it as a part of my Christian duty to make this world a better place for every single human being. The world was not created for some individuals. It wasn't created just for the able-bodied to control, and then those who have impairments, disabilities, be isolated. And it requires those of us who have been entrusted with different responsibilities, and even more so those of us with disabilities who have got the opportunity to sit at the table of decision making, to fight for the inclusion and participation and non-discrimination of persons with disabilities in general. And I deem that as a task with honor. And I'm going to fight with all my life over the next couple of years to make sure that the Caribbean becomes a more inclusive, a more participatory, and non-discriminatory space for persons with disabilities. I have nothing to lose, but we have everything to gain. And whether it be in Suriname, in the south, or it be St. Vincent in the east, or Belize in the west, or Bahamas in the north, the experiences of persons with disabilities are all unique, and we must band together to tear down the walls of discrimination. And we are going to do everything in our powers to tear down those walls of injustice, tear down those walls of exclusion in education, tear down those walls in terms of isolation from employment. We're going to tear down those walls of inaccessibility to education and make this place a better place for all of us. And in so doing, I believe it is reasonable to say to countries within the region, especially those who do not have legislation and have not started the process, that the outer limit of expectation to establish specific legislation for persons with disabilities is a 5-year time. And for those that have established specific legislation, we are giving a 3-year time frame. And there's a reason why I say that, because there's one piece of legislation that requires a 3-year review from the time it is implemented. A 3-year period to make the requisite amendments to the legislation based on some of the things that are in this template but are not in the existing legislation. So there are some countries that can make the amendment within a year or make it in 2 years. But we're saying, you know, at the outer end for those countries that have the legislation 3 years. So between a 3 to 5 year period, we are supposed to see Caribbean countries having specific legislation to protect persons with disabilities. And this will fall within the ambit of the Sustainable Development Goals, which ought to be realized by 2030. So if we have a 5-year time frame, it will take us to 2026. And that means we would be in good stead within the region to realize that target of making justice accessible for persons with disabilities in the Caribbean. So you follow where I'm going. We would be achieving the objects, the obligations of the CRPD by establishing the legislation. And at the same time, we would be accomplishing the Sustainable Development Goals. And then the Declaration of Pétionville would come right into focus in terms of accomplishment. So the time frame is critical and important. So what should happen from here on? We need to have organizations within the different jurisdictions, non-governmental organizations catering to persons with disabilities, forging an alliance with those governments that are here today, because, you know, it's very important. If they never viewed it as important, they wouldn't be in this conference. So the local NGOs have to form an alliance with those governmental institutions to help push for the legislation. And one of the good things, Ms. Isturiz, sorry, I'm spoiling your name. But one of the good things in terms of our contractual agreement with the Center for Disability Studies and UNESCO is that we will be training individuals, young people, as advocates, and also training media practitioners to put the disability agenda across the region. So this is an item that we are going to be placing before them in the training to make sure that they join the advocacy for governments within the region to establish disability-specific legislation. And I heard Bev speaking about the whole issue of capacity building, you know, for countries. The Center for Disability Studies, we stand ready to assist in that process. We have a course, Disability Law and Society, that, you know, fits right within that context. And so, you know, that recommendation from Ms. Reynolds is perfectly in order. And again, we can have further discussion with our partners for this conference as to how we can move to ensure that we build the capacity of the respective countries to complete the legislation. Because what happens is that we have given a template. What you need to do with the template is to plug in the information as it relates to the local jurisdiction, the national jurisdiction. So you know what is your context in education, what is your context in terms of healthcare, and you plug in the information. We now are at the Center for Disability Studies can capacitate individuals to deal with that because of the course that I spoke about in terms of disability law and society. And we have a whole slew of international network that we can tap into to assist in that regard. And then we will be using the Regional Disability Index as a form of monitoring mechanism. We are going to be making some amendments to our Regional Disability Index, which we publish every 2 years. And we are going to be ensuring that we capture information as it relates to the disability-specific legislation, and we'll be ranking or giving scores that would enhance the ranking of those countries that have established disability-specific legislation, because we want to encourage countries to go in that direction. And we will be using the report to put some pressure on countries to establish the disability-specific legislation, because I get from the conference, from the discussion, that there is an understanding and an agreement that we would want to have disability-specific legislation throughout the Caribbean. So that is how I see us moving forward in terms of the implementation of the legislation, to make sure that by 2026, we have all our countries having legislation to protect persons with disabilities. And I think the time frame is reasonable. You know, we have countries in the region that have signed and ratified the CRPD. We have countries that have signed the optional protocol, and we want to make sure now that these countries establish the specific legislation as stipulated under the CRPD to protect persons with disabilities. Ladies and gentlemen, I am excited about the prospects for the future where persons with disabilities are concerned in the region. Legislation is not a panacea to the problems bedeviling persons with disabilities in the region. But what I will say to you is that when you have established legislation, it gives a legal anchor, a legal protection for persons with disabilities in the region, and it binds the crown to putting in place the requisite mechanisms for the protection of persons with disabilities. And again, the point raised by Ms. Reynolds is so important about capacitating organizations catering to persons with disabilities, because one of the things that will have to happen, you're gonna have a lot of persons with disabilities are among the poorest in the world and in the region. They don't have the money that they are going to be able to challenge individuals who violate their rights in the court system. But we have to establish now mechanisms, whether it be through the Disability Rights Tribunal or whether it be ensuring that non-governmental organizations have resources that they can get legal support for persons with disabilities whose rights have been violated and have them challenged in the courts. So we're gonna have to build upon all of these things in going forward. And I am confident that it can be done. It has been done elsewhere. I've seen it done in Australia. I've seen it done in New Zealand. I've seen it done in South Africa. I've seen it done in the UK. And we can do likewise in the Caribbean. The time has come for us to move forward, and we are going to step out with confidence, knowing that the future is for us to make it into what we want it to be. And I am prepared to be at the front and center of that journey. Thank you very much for your support for this conference. Thank you very much for your attentiveness. Thank you very much for all that you have done during this conference. And we look forward to facing the future together. Thank you.
We thank Senator Dr. Floyd Morris for that charge and look forward to the commitment of all our Caribbean partners as we move forward to this, to enable or to ensure that this legislation or this legislative agenda becomes a reality. We want to thank you all for participating today. I know that there were some comments in the chat. Let me just go to some of them before we move forward. Oops. Just give me a second here. Persons were saying, a very informative conference, looking forward to the further advancement of disabilities in the Turks and Caicos Islands. Thanks, Senator and the team for spearheading this very insightful and meaningful conference to move to secure participation, inclusion. Oh Lord, I have lost it. Participation, inclusion, and non-discrimination of persons with disabilities. We look forward to the meaningful outcomes in Jamaica and across the Caribbean. And that's coming from Mrs. Dion Jennings from the Ministry of Labor and Social Security, with particular responsibility for the JCPD at this time. Glenville Liburd is saying, very informative and stimulating conference. The disability sector needs organizing at grassroots levels to become effective self-advocates and lobbyists. Persons with disabilities and their families need to be empowered in knowing their rights under any legislation that is passed, and how to navigate to see that their rights are established and enjoyed. Thank you so very much for your comments and encouragement of the process to the senator who has really been championing the cause, not only here in Jamaica, but right across the Caribbean and, dare I say, the world. I know that many of us here will join in hearts and hands and say, we're right there behind you, Senator. We're right there with you, beside you, behind you. And we know that together we can play our part, because indeed we will be advancing the welfare of the whole human race. And something Senator said that is so true. The world was not created for any one particular type of person or set of persons. The Lord created the world for all of us, and we are going to find our place and make our mark. Thank you so very much, Senator. And to wrap up, our Senator will just say thanks to everyone. I say thanks again for allowing me to participate in this way. It was my privilege and a pleasure, and I look forward to the work going forward. Thank you.
Thank you very much, Dr. Hendricks. And as I move the vote of thanks, I want to thank all the individuals who have been involved with this conference. I want to say special thanks to the participants who have stayed with us for the 2 days and given their insightful comments to strengthen the document that we prepared. And so I thank the ministers, I thank the permanent secretaries, I thank the Attorney General that have been here. I thank all the technical teams that have been here. I thank all the members of the academic community and the community of persons with disabilities who have joined us directly in the conference and on YouTube to give the support for an important conference of this nature. When we started out the planning of the conference in March, the target that we had set initially was about 50 individuals when we took into consideration the ministers with responsibility for persons with disabilities and their permanent secretaries and the attorneys general. And when we checked yesterday, there were close to 100 persons in the conference, because as we drew nigh to the conference, excitement was triggered across the region, and people up to the morning of the first day, yesterday, Ms. Archer, who is the coordinator for the conference, was getting emails from individuals to say they want to get on, they want to get in. Is it too late? And we had to oblige one and few of the individuals, because the nature of the conference, we had to be very selective and targeted in terms of invitation. And so we have exceeded our target significantly. And we thank all the participants. And then, you know, when you are planning a conference of this nature, it requires financial resources. If you don't have money to do the things that we have done for the conference, technology don't come cheap, and this conference was driven and streamed all over the region via technology. And that is not something that comes cheaply. And we also put out a nice keepsake conference booklet. I'm certain that you all agree that those who have received the printed version, that it's a wonderful keepsake. And, you know, those are some of the things that, you know, we had to fund for the conference, right? And so we had to get support from our partners. And I want to say to our partners, Digicel Foundation, UNESCO, the Commonwealth Secretariat, our heartfelt gratitude, because this could not be done without you. I mean, I spoke to Digicel in March, and in April, I got the check. I first approached UNESCO about some training issues, and then we added the conference into the pot, and they came in and gave tremendous support. And they never just only give us the financial support, they gave us technical support, and they came on board and were there with the planning committee. And I want to say to Paula and Juliana, who anchored from UNESCO, that we really appreciate the support, and we appreciate the tremendous effort that you have made. And please convey to Ms. Sanchez and Ms. Gabriela Ramos our profound appreciation, and that we look forward to the continued cooperation in terms of your support. And I know that it's late in the night in the UK, and so my partners in the Commonwealth Secretariat wouldn't be around, but I want them to know that we really appreciate the support, because the lion's share of the funding of the conference came from them. And, you know, they are not just going to be supporting the conference. They have given us a grant to do research on the issue of access to health care in the Caribbean, and also to make sure we develop some policy briefs for governments based on the research that we have done. And they have said to me that, once things goes well in the first year, then they are prepared to look at the second and the third and the fourth and the fifth. All right. So we look forward to strengthening those relationships and those partnerships. And I'm really happy. And then I hear everybody say, oh, Floyd Morris, Senator Floyd Morris and thing, yeah. But it would not have been possible without the team, the dream team that was around me. I've conceptualized the conference. The next thing was to get a team that believe in the dream. And those individuals who are present in this room this afternoon, and I'm going to ask Devante, can you put the camera on them if they stand up, Devante? All right. So I'm going to ask them as I call the names to come forward. So if Jason and Shavin would love to be on the outside, then better come inside. And Sharma Lee Cardoza camera, please come inside. But I want to say that these individuals who are a part of the committee gave human service to making this conference a reality. And I want you to know that I love and respect every single one of you. Uno make me glad bag one boss. Me happy. Me happy. Me happy. And I want to say to Dr. Hendricks, Dr. Christine Hendricks, stand from the Jamaica Council for Persons with Disabilities. Miss Jacqueline Bennett had an emergency and had to run out, but Miss Bennett from the JCPD, and she anchored the whole issue of situation of refreshment for the 2 days. And, we are deeply grateful to Miss Bennett. Miss Gloria Goff of the Combined Disabilities Association. Boy, them say she lick a bit, but boy, she talawa. Thank you very much, Gloria. You know that I'm not going to have a conference and don't include you. Miss Tamisha Powell, also associated with the Jamaica the Combined Disabilities Association. Thank you very much for your support, tremendous support on the committee. And you and I work together tremendously to make sure that the template was formulated and ready for today. I want to thank Miss Beverly Reynolds from CARICOM, who is on screen. Thank you very much for your tremendous support and input. Want to thank Miss Kerry-Ann Eiffel in Barbados, who also gave tremendous support to the planning committee. We want to thank Mrs. Nicola Barker Murphy from the Ministry of Foreign Affairs and Foreign Trade. Again, tremendous support, Ms. Barker Murphy. And you know, you fit in so nicely with all the things that we did. And once we asked, you responded. And we are extremely grateful. Paula Isturiz of UNESCO, thank you very, very much. You know, you gave us support for the side event. You gave us support for the main conference. You have been there through every nook and cranny of the conference, and we appreciate your efforts tremendously. And Juliana is online. All right, well, tell her up that while she's sleeping, we are bigging her up. Thanks to Juliana as well, because she gave tremendous support. And then I have to go to the team that work closer with me on the conference. I mean, Shamali Cardoza, camera. Shamali Cardoza, camera. Where is she? Okay, good. All right. Thank you very much for your tremendous support. You know, you have always been there. You know, we work together, the Center for Disability Studies and the Office for Special Student Services. And when I start doing anything and say, Shams, we're going to work on this, and, you know, you say, when you're ready, call me. And you have been there, and you did an excellent job with the side event yesterday. Commendations to you. Thanks to Jason Ricketts, research assistant. Make sure that, you know, research the different things for information for the conference. Again, Jason, thank you very much. And, you know, we hope that we're trying to build a cadre of young people to take over the work in the future. And Jason is one of them. He should be starting his PhD at the University of the West Indies come September. And commendations to Jason for his effort. Then Shavane Daly. Shavane, thank you very much for your tremendous support. And I know you're going back down into Clarendon tomorrow, but I hope that you will come back to the city in short order, because he too is going to start his PhD come September at the University of the West Indies. And Delane Fraser. Delane is the person who gave secretarial support and did a tremendous job where the conference is concerned. We want you to know that we really appreciate your effort, Delane, and we will continue to work together. You know, there are some people where me can work with and me can beat them up and get to, you know, because, boy, you know, there's much more than a working relationship. There's a friendship. And my wife said to me, say, boy, when you start quarreling, me not get involved with you and her. And that is Mrs. Chevelle Gerson Robinson. And I want to thank her for her support. And she worked with me for a number of years, both in a private capacity and the Center for Disability Studies. And, you know, she's now working elsewhere, but she knows the system very well, and she knows the institutions that has given us tremendous service. And so I had to call upon her to assist in that regard. And, you know, I really appreciate the effort. And then Miss Gladys Feller. Now, some people will wonder how the name spell like that. And that was the first thing that I asked Gladys, you know. But Gladys is a citizen from Guadeloupe and a graduate of the University of the West Indies, Cayville campus, and she did her master's in accessibility for persons with disabilities. And what has drawn me to Gladys and caused the connection is that Gladys came to Jamaica last year, and I am so impressed because Gladys reached out to me, volunteering her services to the Center for Disability Studies. And she did that for about 6 months, and then she came back. And when I said to her, you know, we're having this conference and I want your support. And she said, I am in, I am ready. And she has been there from the get-go. So all of the supportive documents that are there, she has worked and participated in that. And I will tell you that you are not going to see the end of Gladys around the Center for Disability Studies because there are some things that are pending. And so she's somebody for you to know and be aware of. And Miss Pamela Archer, I want to thank you very much. This is Miss Details. This is Miss Details, you know, and she write down everything. We have to say to ourselves, Lord have mercy, you're a real teacher. Because already have the computer, she writing it down in a book. You know, and Gloria, she'll look out for every I and she'll look out for every T. And when she miss a I and she miss a T, she is so concerned about it. You know, she lose sleep. And her concern was consistently about making the conference an excellent one. And so, Ms. Archer, you can sleep well because we did have an excellent conference and you did a tremendous job, you know, for the conference. And these guys were not a part of the conference team, planning team, but we have to thank the volunteers who came in and gave us tremendous support over the 2 days. And we want you to know we appreciate the tremendous effort that you gave. And I have to say a heartfelt gratitude to Devante and Joshua and Ms. Keisha Sherman for the support that they gave for the conference in terms of the technical support. And, you know, we had our glitches, you know, but let me tell you something. No conference of this nature could be held without technical glitches. I have been to many of them across the world, and I've not seen one that never had its technical challenges. So thanks very much, and thanks to Miss Francis from the regional headquarters for the accommodations that have been provided, and we really appreciate it. And we have to also thank the caterer for the food that have been provided. Most importantly, okay, we have to thank also the interpreters for doing a tremendous job over the 2 days, the sign language interpreters and the French interpreters. Thanks very much for the tremendous job that you have done. And yeah. So we want to thank you very much, and we look forward to continued good working relationship. And I said to you all in the email group last night that no COVID is going to prevent me from taking pictures with you today. So they can come and prosecute me afterwards. But, you know, thank you very much. Appreciate it. And it is more love. And we look forward to securing participation, inclusion, and non-discrimination of persons with disabilities through legislation across the Caribbean. One love, God bless you, and I love you all. Thank you very much. All right, Bev, I see your hand.
Great job, great job. Congrats.
All right. Thank you, thank you, thank you, thank you. All right, thank you very much. That's the end of our conference. God bless you.
Great event. Thank you.
All right. Yes, yes. Juliana? Yeah, and I need to...